but when they'll go to court. Good morning, everyone. In the name of the Commonwealth of Pennsylvania, this court of common pleas is now declared open. Judge Glynnis, self presiding.
Okay, good morning, everyone.
Morning, Your
Judge.
Honor.
All right, Janice, how are you?
Good, Judge. Thank you.
Good. All right, I'm going to start off by reading some general instructions to everybody, and I'm going to do it one time. That way I don't have
Good
to.
morning, everyone. In the name of the Commonwealth of Pennsylvania, this court of common pleas is now declared open.
What?
Judge Glynnis, self presiding.
Okay.
Hold on. No, I get this. It's at the YouTube. It's on delay. Hang on.
Janice, how are you?
Hold on. Let me get off the
All right,
YouTube
we're
thing
gonna
here.
start off-
Whoops. There we go. It's on delay.
Okay, sorry about that. We're on YouTube, so there's a lot of stuff going on here. So let me repeat myself. I'm going to read some opening instructions to everybody, all attorneys and parties who are involved in today's listing. And I'll read it one time. That way I don't have to be repetitious and read it each time I do a hearing. And then as I do each individual case, I'll have a few questions for each attorney and each party individually. But this is the opening instruction. So if everyone could be attentive, I would appreciate it. And I'll do it one time and that'll be it. This is an instruction we're supposed to read from the First Judicial District at the request of our administrative judge. Since we're doing these proceedings by way of YouTube, by way of Zoom. And the instruction is as follows. All parties, counsel, and participants are to follow the court's notice to the bar, policies and protocols for the use of advanced communication technology for court proceedings and civil matters. The parties should have received these notices as attachments to their scheduling orders forwarded by the court. Additionally, counsel should have provided a copy of this notice to each participant that they intend to invite to this proceeding. The court expects that everyone will remain civil during these proceedings. Only one party should address the court at a time, and the court can mute any party's microphone if need be. Counsel and parties must silence all other electronic devices. There is a court reporter transcribing the proceedings, so it is imperative upon everyone to respect these rules so that the record is memorialized accurately. Pennsylvania Rule of Judicial Administration number 1910 provides that it, quote, is unlawful and a criminal offense to use or operate a device to capture, record, transmit, or broadcast a photograph, video, motion picture, or audio of a proceeding or person within a judicial facility or in an area adjacent to or immediately surrounding a judicial facility without the approval of the court or presiding judicial officer or except as provided by rules of court, period, end of quote. The Zoom proceeding takes place in a virtual courtroom and constitutes a judicial facility. As such, any broadcasting, transmitting, video recording, audio recording, photographing, taking screenshots, and/or otherwise saving or reproducing the proceeding is strictly prohibited and subject to penalties, including contempt of court. During testimony by a party or witness, no one is permitted to communicate via text or chat application or by any other means with the testifying witness, except by way of the record oral questions directed toward that witness. If counsel is muted and has an objection or would like to address the court, counsel should physically raise their hand so that the court may recognize counsel. If during the course of the proceeding it becomes necessary for counsel to consult with a client in private, counsel may raise their hand to request to be sent to a breakout room for a short time to have a private conversation. If the court requires a sidebar conference with the attorneys, a breakout room can also be created to have a private conversation. If a participant's video freezes and that participant is unable to restart the video, the participant should dial into the Zoom proceeding and use audio only. The parties should have received the appropriate telephone number to dial into this video hearing as a part of the scheduling link emailed several days ago. Participants are reminded that everyone must appear on camera during the entire hearing, whether or not they are speaking, unless the court directs otherwise. And participants must limit or eliminate possible background distractions. Lastly, all participants must be able to to review exhibits while also participating in a Zoom proceeding. There is a share feature as part of the Zoom interface, so council is directed to utilize this if they plan to display documents to the court. The court should have received all documents from the attorneys prior to this proceeding, and the court reporters should have also received copies of the submitted documents. So having said that, we're going to now call individual cases. And then I have a few minor instructions as we talk to each part, all the parties individually as it relates to both cases or each cases. Excuse me. All right, go ahead.
All right, case number 1, Coles v. Neal, case number 00530, July term 2021.
Who are the parties? Are the parties present for Coles?
Yes, good morning, Your Honor. Joseph Russo, I'm the attorney for the plaintiffs, Tyrone and Mary Coles.
Okay, how are you?
I'm good.
Good. And are the defendants here? Is Ellis Neal, Dina Neal, or Robert Stevens present?
Mary Coles.
Yes.
Who?
Mary Coles is present also.
Who?
I think they're all on. I think I've seen them, Your Honor, somewhere on the screen.
All right, where,
We are all here.
okay.
Yeah, well, they might be calling in. They're there. I think they popped up.
Okay, okay. Yeah, make sure that you pop up in the video so I can see you. All right.
Very quickly, Mr. and Mrs. Neal, if you're in the same room, both on the, and you have 2 devices, both logged into the Zoom meeting, we're gonna get feedback. So I suggest that one of you mutes yourself.
Did you hear that?
Yes.
Okay. And Mr. Stevens, are you also present?
Yes.
Okay.
Mr. Stevens, do you have a video capability, or is it just audio?
I have video and audio.
There it is.
All right. All right. So before we get started, I just need to be sure that all the parties who are involved with this proceeding are consent to do this proceeding by way of Zoom. So as far as the attorney is concerned, the plaintiff's counsel, you agree to do this by Zoom?
No.
Yes, we do, Your Honor. And I just want to let you know, Mr. Coles is here. Mr. Neal is here. Miss Coles, his mother, is not here. She's in a nursing home. He does have power of attorney for his mother, which I tried to upload this morning. Hopefully you got it. So she's not present for the hearing, but he's here for both of them.
All right, and that's Tyrone?
Tyrone Neal, yes.
Okay, fine. And what's his mom's name?
Mary Coles,
Mary. Okay. But he has power of attorney for her.
yes.
Okay.
She is right here.
All right, I understand. Gotcha. All right. Can you swear the parties in real
Sure.
fast? All parties who are going to be a part of this proceeding, I'm going to have someone swear you in because I need to ask you a couple quick questions before we get started.
All right, can all parties please?
Hello,
raise their right
excuse
hand?
me, can anyone hear me?
Yes, we can hear you. Can you please mute yourself while we continue?
Yes, I'm having problems with my computer, but I'm here, Patricia Wade.
Okay, we'll get to your case in a moment, ma'am. Can you please mute
All right,
yourself?
sorry, thank you.
All right, listen, before we get started, I need everybody to just let one person talk at a time and just listen very carefully to what's being said so we're not over talking one another. We can get through this, okay? Is everyone with me? All right, thank you. So I'm going to have someone swear in the parties now before I ask you any further questions, and those questions won't be long.
All right. Could I have the plaintiff and defendants please raise their right hand? You swear that the testimony you'll give to the court today will be the truth, the whole truth, and nothing but the truth.
Yes.
Did everyone answer?
Yes.
All right, stop, listen, for those who are in the background, you can't talk, you gotta listen.
1 second, I gotta mute these people. Okay.
Mhm.
All right, I've just muted all of you except for us. Could the defendant and plaintiff in this matter, Coles v. Neal, please unmute yourselves? Thank you.
Unmute yourself. Unmute yourself, Dean.
Well, I'm sorry, again, if you're in the same room, we can only have one device active in the same room. Otherwise, we'll get feedback.
Okay, are we ready?
Yes,
Okay, so, all right, everyone has consented now, and I've already read my expectations. I'm going to turn the floor over to plaintiff's counsel so that you can give your quick opening statement, sir.
Thank you, Your Honor. Just briefly, it's a petition for ejectment. Mr. Neal and Ms. Coles. Well, Ms. Coles was the owner of the property. She added her son to the property back in, I believe in June of 2018. So now they're the co-owners of the property of 61. Co-owners of the property of 6123 North Franklin Street. The defendants, Ellis Neal, Deanna Neal, Robert Stevens, did go to the property sometime, I believe it was in 2019. They were there when Miss Coles was still living at the property, and I believe it was her sister, right? Her aunt that was also living at the property. So they went there, and they went there to kind of help to take care of.
Who's talking?
Hold up, Dean, calm down.
Listen, you gotta listen and not over talk, okay? If you can't, well, then you can't participate in the hearing. Listen. Mr., is that Tyrone?
Yeah.
My
yes.
name is Ellis.
Excuse me?
I'm Ellis. I'm his nephew.
Okay, whoever's with you, they need to be quiet, please. All right, so I can hear what the attorney's saying.
Yes.
Thank you, I appreciate that. Go ahead, sir.
Okay, thank you, Your Honor. Yeah, so Ellis Neal, Deanna Neal, Robert Stevens were in the home sometime in 2019. They were taking care of the aunt of the plaintiffs. That's why they were in there to help out to take care of the aunt. The aunt passed away in March of 2020. And
what was her name?
What was her name? Hannah Henry was the aunt. She passed away in March of 2020. I'm sorry, March of 2021. She passed away. In 2019, Mary Coles had already left to go into the nursing facility. So 2019, Mary Coles goes in the nursing facility. Hannah Henry passes away in March 2021. At that point, the three defendants were asked to leave the property, and they've just remained in the property since. Again, my clients are the owner. There was never any rental relationship between the parties. They were permitted there at one time, like I said, to help take care of the aunt. But since March of 2021, the three of them have been living in there by themselves, and they have refused to leave despite request. So we were asking for an order in ejectment today to get them out of the property.
Okay.
Want it?
But they, sir, you have to be quiet, please, if you don't mind, so I can hear the attorney. All right, so the point is this, where, and you may have said this, counsel, and if you did, forgive me. Was there any like will or anything like that? Mary Coles,
No,
repeat what you said as relates to Mary Coles again.
yeah, I'm sorry. So Mary Coles and my clients, Mary Coles, and this is her son, Tyrone Neal. They're the two owners of the property. The aunt that passed away, Hannah Henry, she had no ownership in the property. She was just residing at the property.
Okay, I got you.
Mary Coles is still alive. She's just in the nursing facility.
All right, and it was Coles and your client here who was the owner of the property.
Yes, they're the two owners.
All right, then their names are on the deed.
The names are on the deed, yeah, which was included in the attached to a copy of the complaint.
All right, fine. So there's no issues of wills or anything like that?
No, nothing like that,
Concerned
no.
with. All right, all right, thank you. All right, so do you want to, does the defendants, do they wish to give a very quick opening if they want to? And then I'm going to take a little evidence from you, counsel, and then we'll be done with this because it seems pretty straightforward. Does the defense wish to add anything very quickly as far as just an opening statement?
We do not have a lawyer, but we were told we could stay there by Ms. Coles.
All right, put yourself on the screen, please, so I can see who's talking. Huh? I know. All right, there you go, sir. Now identify yourself, please.
My name is Robert Stevens.
Now, whoever was talking, I need whoever was speaking to identify yourself so I can see who and we can make a record. Sir.
Yes.
Look at me, all right? Were you the one speaking, sir?
Yes, I am. And because they have 5 doctor lawyers, and it's the case for Minnesota.
Excuse me, who is speaking?
Into Chinese.
Robert Stevens.
I'm doing the best I can. What we got? Not just ones here, like they're actually worse. Only have you through. I want my voice.
All right. I'm gonna put on, where's Mr. Stevens here? All right, Mr. Stevens, could you please unmute yourself? Mr. Stevens, you're muted. Can you please unmute yourself?
Yes,
All right.
Go ahead. Now, this is your opportunity to just give me a quick opening of what your position is, sir.
my position, I'm the fiance of Deanna Neal.
And identify yourself for the record. I know it's Mr. Stevens. What's your first name?
Robert Stevens.
All right. And so in one paragraph or so, what is your position?
My position, I'm fiance of Deanna Neal. We've been staying there because Ms. Cole said we could stay there. Now, in fact, if you, in fact.
You say Mr. Cole, when you say Mr. Coles, who in particular? Oh, Mrs. Coles. You said Mrs. Coles?
Yes.
Okay. Go ahead.
Do you want to hear from Mrs. Coles?
Do you have her as a witness?
Yes.
Okay, when the time comes, I'll hear from her. All right, so I think you stated what your position is. Does anyone else, any of the other defendants wish to say anything? Give a very quick opening? I'm sorry, yeah. Can everyone hear me? The other two defendants?
I muted Mr. Neal,
They need to-
Yes, ma'am. Yes.
Go ahead, sir. Identify yourself very quickly.
Yes, my name is Ellis Neal. I'm
Okay,
here with my Nana right now, Miss Mary Coles. I've been at the residence since 2018. Whatever my uncle is, he's still my uncle. Whatever my uncle is going through, he's going through. But he wants us out the house because he wants access to the house.
all right, fine. And you have,
My grandmother, my Nana is right here.
all right, all right, fine. We'll get to her in a second.
Yes.
And Mr. Stevens, is Mr. Stevens present?
yeah, he was just
Or was that Mr. Stevens?
Robert Stevens. That was,
All right.
that's who he was.
All right. All right, so let's do it this way. We're now going to turn the floor back over to the plaintiff's attorney. You want to put on some evidence, sir?
No,
Yes, thank you, Your Honor.
turned everything off, man.
I don't know if I understood right. Are they there with Miss Mary Cole? I don't know. My client's a little concerned that they actually have gone into the nursing facility for the hearing. Is that?
Yeah, it looks like they may be there. They have, apparently she's there.
Okay.
Okay.
Yeah, all right. Well, like I said, he has power of attorney for his
I
mom. She's
understand.
not in- Yeah, all right.
All right, go ahead. But this is your time to put on your evidence, sir.
Yeah, all right. No, that's all right. Thank you, Your Honor. And I would call Mr. Neal, the plaintiff, Tyrone Neal.
Okay.
Mr. Neal, could you state your name for the court?
I'm sorry, just one second. We have to mute 1 second. I'm sorry. We have to mute the defendants since they are in that room together while All right, continue.
All right, thank you. Mr. Neal, could you state your name for the court?
Yes, my name is Tyrone E. Neal.
And where do you currently reside?
I currently reside at 5632 North 7th Street, Philadelphia, Pennsylvania, 19120.
Okay. And are you one of the owners of 6123 North Franklin Street?
Yes, I am.
Okay. Who are you owner of that property with?
I am co-owner of the property with my mother, Ms. Mary Coles.
Okay. When did you get ownership of the property?
My mother had my name had told me to have my name put on the house in 2018, January. I believe it was like January the 29th or something.
I have a deed that shows January the 29th of 2018. Is that correct?
Yes.
Okay. And I would just offer the deed, Your Honor, into evidence as P1.
Okay, so admit it.
Who currently resides at the property?
Ellis Neal, Robert Stevens, and Deanna Neal.
Could you tell the court how they came to reside at the property?
Yes, Your Honor. Ellis Neal was incarcerated. He came to the property. He asked my mother, could he stay? And before that, my aunt wouldn't allow it. She was the owner then. My aunt wouldn't allow it, so he left. Ellis got locked up again, came home. My aunt was older now. She was maybe 104, 105. So he pleaded with my mother. So my mother told him he could stay for a while to try to get himself together.
When was this?
I think this was in 2018.
2018, okay. And he went to move in with your mother was residing there at the time?
No, this was 2019.
Okay, and your mother was residing there at the time?
Yes.
Okay, and your aunt was residing there at the time?
Yes.
What was your aunt's name?
My aunt's name is, her name was Hannah R. Henry.
Okay, so Ellis Neal went to reside with your mom and your aunt in 2019?
Yes.
Okay. At some point also in 2019, did Deanna Neal and Robert Neal also begin to stay with them?
Yes.
Okay, could you tell Your Honor how that came about?
Okay, what happened, Your Honor, how Deanna and Robert Stevens came in, I had another niece living there, taking care of my aunt, the one that's in her hundreds. So she apparently abandoned my mother, she abandoned my aunt, so I had to ask Deanna Neal, could she come and care for my aunt? She could stay there as long as she was caring for my aunt, and we even paid her. So then she had the boyfriend, Robert Stevens. I told him he could also come because I would feel comfortable if people were always around because I was constantly working.
So they were in there to help take care of your aunt at the time?
Yes,
Okay.
they were in there taking care of my aunt.
And this was 2019?
In 2019.
Okay.
And I am the one that gave them the permission to be there solely to take care of my aunt.
Okay.
And they knew once my aunt passed, eventually they would have to find somewhere to live.
Okay.
All right, and how old was John again?
When my aunt passed, she was 107.
Okay.
Okay. She passed, when did she pass away?
She passed last year.
Okay. Do you remember the date? The month?
Her birthday's in April. I think she passed in March, around the middle of March last year.
Okay. And at that point, did you ask them to leave the property?
Well, Ellis Neal was already under eviction. The eviction got sidetracked because of the pandemic.
All right, so you had already tried to evict Ellis Neal?
Yes,
Let me just clarify. When you say evict, you mean you had filed a previous
Yeah,
previous ejectment action?
yes,
correct?
I filed a previous ejectment. And I was waiting on a court date, and the court date was supposed to be around the end of March. And what happened was the court date got pushed up without my knowledge. I came home from work, I believe it was March the 11th. I had a letter in the mail because I was constantly looking for this court date. I was even calling City Hall. So when I got home from work that day, opened the mail, the court date was pushed up to the 11th at 9:30 in the morning. I had no knowledge.
Right, so you missed that. You had to refile the ejectment
Yes,
action.
so I had to refile everything.
Okay. And just to clarify for the court, when did your mom have to leave the property? When did she have to go into the nursing facility?
My mom went to the nursing home. I believe it was probably October or November of 2019.
And she's been residing there since?
And she's been residing there since.
Okay, and then at some point, did you take power of attorney of your mother's?
Yes, I had to get power of attorney over my mother just so I can do all the paperwork to get her in a nursing home, because I could not leave her in that house because it was just too much going on and they could not care for my mother. My mother needed 24-hour care.
All right, how old is your mom?
My mom now is 87.
All right, and when did you get power of attorney?
If the document here shows November 15th to 2019, does that sound right?
Yes.
Okay,
And Your Honor, I'll mark that as Exhibit P2 and enter that into evidence.
all right.
Power of attorney. Okay. Mr. Neal, so just to clarify, so they've been living in the property 6123 North Franklin without permission since?
They've been living in the property without permission ever since my aunt passed away.
Okay.
I told them originally, you know, once she leaves, once she passes away, you will have to find somewhere to live. And I offered, Your Honor, I offered to help them find somewhere to live and even support them financially. Once they found somewhere to live, I was going to put up the money to pay just so they can move in there so that they would have somewhere to live.
Okay. Anything else, counsel?
No further questions, Your Honor.
All right, thank you. Do you have any other evidence that you would like to present in support of your case?
No, outside of the two, exhibits that were marked,
All
the
right.
plaintiff would rest.
You submitted all your exhibits, yes?
Yes.
Okay.
Like the power of attorney, I emailed, yeah, I think
All right.
I emailed correctly, but let me know if you don't have it, I'll resend it.
All right, thank you. All right, and you rest?
I do rest, Your Honor.
All right, now I'm going to turn to the defendants now. Mr. Ellis Neal, can you hear me?
We muted you, Mr. Neal, if you want to unmute yourself.
Your Honor's plaintiff's attorney again, maybe I guess it's the same issue for all three, so it's probably not a big deal, but we did get a default judgment against Ellis and Deanna and Neal. They never
Okay,
responded.
so you did get a default judgment against them?
Yeah. we
Okay,
did get
good.
a default.
You probably should have mentioned, but you should have mentioned that up front.
I know, I was a little, I kind of slipped my mind with everything at the beginning, but yeah, we did get a default against them. Robert Stevens did answer the complaint.
Okay, fine. So let me start with Robert Stevens then, real fast then. Mr. Stevens, can you hear me?
Yes.
All right, Mr. Stevens?
Yes.
Put your,
Mr. Stevens, you're muted. I'm going to mute Mr. Neal real quick. And Mr. Stevens, if you could unmute yourself, please. Thank you. There you go.
Yes.
all right. All right, thank you. Now, this is your up. Would you like to put on any evidence, sir?
Yes.
Go ahead, sir. The plaintiff has now rested his case, and this is your opportunity to put on evidence before the court if you choose to.
Mr. Stevens, you have to unmute yourself.
Okay, I'm unmuted.
There you go. We can hear you.
All right, so this is your opportunity to put on evidence before the court if you choose to. Do you wish to put on any evidence?
Yes, all I can say is Ms. Cole said I didn't have to leave.
Okay,
And,
all right.
yeah, you want to speak now?
Anything else?
Yes, yes.
Your,
Okay.
Your Honor, I would object to any testimony from Ms. Coles at this point. I don't know what, they've gone into the nursing home the day of the hearing. I don't know if she knows what's necessarily going on. You know what I mean? I just would object to any testimony from Ms.
Well,
Coles.
counsel, I see your concerns, but since she is there, yeah, I'm going to, and I heard everything you said, counsel. I haven't missed a beat, but I'm going to give her a chance to make a record since we have her. It's already, they're already there. Ma'am, just, can you hear me?
Yes,
Can you raise your right hand? Do you swear to tell the truth and nothing but the truth, so help you God?
so help me God.
All right. So, Mr. Stevens, do you have any questions for her very quickly?
Ms. Cole, did you say it was all right for me and Deanna Neal and Ellis to stay there?
Yes, I did.
At any time, did you ask us to leave?
No,
I rest my case, Your Honor.
All right. And when did you tell him he could stay there, ma'am?
oh, I don't remember. I'm in the nursing home. I don't remember.
Okay. All right. Thank you. Anything else, Mr. Stevens?
No, sir.
All right. All right. Give me 1 second.
Okay.
Tell me, Deanna's ready.
All right. Mr. Ellis Neal, can you hear me?
Mr. Neal, you're gonna have to unmute yourself. I'm going to mute Mr. Stevens. And
Hey, Nana.
there you go.
Yes.
All right. Do you wish to say something since you're here? You've been sworn in.
Hold on 1 second. I'm sorry. Very quickly, our steno got knocked off, apparently. Sorry, just one moment. Our stenographer has had some technical issues.
Yeah, that shouldn't even be allowed.
It's about the house or me going.
All right, there she is.
It's about the house, man.
Okay, all right, continue, Mr. Neal.
Yes.
Yeah,
Good
this
morning,
is, I'm giving you a brief opportunity if you choose to put on evidence or say anything that you heard
Your
what
Honor.
the plaintiff, you heard the plaintiff put on his case.
Yes, Your Honor. I've been at the residence since 2018. Came home, I was incarcerated. My family said, come to the house. I was out in Vegas and my family said, come to the house. I didn't know what was going on at the house. I came to the house. My grandmother said that it was wonderful that a man was in the house now. Because when I got there, it was just women in there.
Okay.
Mr. Stevens wasn't there yet. It was just women. When I came to the house, my grandmother, my nana said that I feel comfortable that there is a man in the house.
All right, fine.
And was home. My grandmother was at the house at that time. She was living there at that time. So my uncle, he was trying to get money. I was giving my uncle $400 a month rent that I was paying him.
Is that Tyrone?
Yes.
Okay. All right, fine. So when was this, sir?
This was I started paying him. I'm gonna say around May 2018. I was giving my uncle $300 or $400 a month.
Okay. All right. So, but you said your family said you can come to the house. Who in particular?
Yeah. My mother, my grandmother, like my uncle, his brother also told me to come to the house. Like I said, I was incarcerated. I didn't know what was going on, Your Honor. And when I finally got to the house,
okay.
yes.
All right, I understand.
I've been living there since 2018.
All right, thank you. Anything else, sir? You better try to-
My uncle has been
Yeah.
locking up he's making it uncomfortable for us. He's
All
been
right.
locking up the water heater. He's turned off all of we're paying the utilities right now.
Okay.
My uncle turned all that off, locked it up, locked
All right,
the hot water heater up, took out the toilet. Like my
All right,
uncle been going crazy.
Anything else, sir? Very quickly.
That's it, sir. That's it, Your Honor.
Thank you. And what
My
about?
grandmother already said what she said.
All right, thank you.
Thank you.
Dina Neal, can you hear me? Dina Neal, unmute yourself and,
Can you hear me?
yes, good.
Hi, my name is Deanna Neal. I was living at my grandmother's house in 2017.
All right, you were sworn as well, right? Excuse me,
Oh,
you were
yes.
sworn already, right?
Yes,
All right, you swear to tell the truth and nothing but the truth, so help you God.
yes.
All right, go ahead. So go ahead, man.
I was living at my grandmother's house 2017. I was taking care of my grandmother and my Aunt Hannah. Up till my grandmother couldn't walk. She couldn't walk in 2018. I can't remember when I called my uncle to tell me we had to take her to the hospital. She had a bad moment. A bad moment. The reason I couldn't take care of her no more because I had to lift her, walk her to the bathroom, stuff like that, up till 2019. In 2019, that's when she got resident into the old folks' home, but I was still taking care of my Aunt Hannah. I was taking care of my Aunt Hannah, washing clothes, cleaning up, taking care before he even started helping me, started giving me money. I was doing it with my own check, buying payments and stuff for my grandmother and my Aunt Hannah. So then I told my husband to move over there to help me with her. That's when he decided to come over there and help me with her.
And your husband is?
But Robert.
All right.
Robert. So I was still staying there. When my Aunt Hannah passed away, that's when he wanted us to get out. But at the end of the day, I'm family, and he should have did me like the way he did when his family didn't even come and take care of my grandmother, help her, or my Aunt Hannah. It's all about the money. That's all it is.
All right, I understand. Anything else, ma'am?
No.
All right, thank you. You do agree your name's not on the deed, right?
Who?
Your name.
No, my name is just on the bills.
All right. And to the best of your knowledge, Robert Stevens' name is not on the deed?
No.
And neither is Ellis Neal, right?
No.
All right, thank you. All right, anything else?
Yes, and I have paperwork to prove that I have how long I've been in, how long I've been taking care of my grandmother and everything.
All right, thank you.
Okay.
All right, thank you. Any other evidence on behalf of the defendants?
No.
All right,
My
thank you.
grandmother already said what she said.
All right. So in closing, Mr. Russo, would you like to have any parting words? Because we're done, pretty much.
Yeah, thank you, Your Honor. I mean, I think it's pretty straightforward case. You heard the evidence.
Right.
It was commendable one time that they were in there to help out, but there's no.
All right, thank you.
And
Defendants, I think I understand your position as well. Any parting words on behalf of the defendants? Would anyone like to say something very briefly? All right, I assume not. Okay.
Okay, wait a minute.
Go ahead. I think you said what you had to say.
Yeah.
Okay, so I assume you would just repeat sort of what you just testified to.
Yeah, my grandmother already said that I can stay there.
Okay. All right, thank you. That ends this proceedings, and I'll be sending my order out very shortly, later on this week, okay?
All right.
All right, thank you, everyone. That ends this
Thank you,
that ends this particular hearing as it relates to this case. Next.
Thank you, Your Honor. Can we be excused from the
We can hang up?
Excuse me, I'm sorry. Go ahead, counsel, Mr. Russo.
No, so we could be excused from the Zoom hearing?
Yes, you're excused.
All right. Thank you,
Everyone
Your Honor.
relating to this case is excused.
No, was a whole get you
Thank
say?
Right, sorry for all the confusion. It's too many parties. I wish this were done in the open courtroom. Unfortunately, we have to do this by Zoom.
Yeah. I did it. You ain't gotta go nowhere. No.
All right, case number 2, Lohman v. Greer, case number 02316, July term 2021. Again, that's Lohman v. Greer. Might have it on.
All right, it looks like the defendants, two defendants haven't filed an answer. Is the plaintiff here, for Lohman versus Diamond E. Greer? Can anyone hear me?
They can hear you. You're on.
All right. Nate Lohman, are you present at this hearing?
Guess not.
All right, just so we're clear, is there any representative for the defendant present at this Zoom hearing? Okay,
Non-press.
all right, next case.
All right. Case number 3, we're gonna go up Jones v. All Occupants, case number 00081, August term 2021. Jones v. All Occupants.
Jones is here,
Laura
present.
Jones.
All right, good. What about any of the defendants? Stephanie, Jerome, anyone present on behalf of the defense? Okay, Ms. Jones, I'm going to turn the floor over to you.
Okay. Well,
Put
swear
yourself
that
on the
all-
screen, please.
can you see me? I don't,
No.
okay. Start the video. No, it's not. Okay, what do I need to do?
On the ma'am, in the bottom left hand of your screen, there should be a little camera icon next to a microphone icon. One says mute, one says start video. Hit just click
Right.
on the start video.
Allow access, okay. It's still not unchecking the video.
Do you have a camera, ma'am?
Yes,
I don't know. So,
All right, so go ahead, ma'am. This is your opportunity. Give me,
okay, I'm basically the
first of all,
executive.
I'm going to swear you in, okay?
Okay,
Raise your right hand.
and ma'am, do you swear that the testimony about to give to the court today will be the truth, the whole truth, and nothing but the truth?
yes,
Okay, so if you just give a quick opening statement, this shouldn't take too long.
Nope.
It doesn't look like the defendants are present, and it doesn't look like, it looks like that you did serve them, but they failed to file an answer. Is that your understanding?
yes, that's correct.
All right, that's what the docket seems to suggest as well. All right, so why
Yeah.
don't you just quickly state your position? This shouldn't take too long.
Okay, my position is this. I'm the executrix of this, I guess, property. My former aunt who passed away March 19th, 2020.
All right, her name was Shirley Watson?
Yes, Shirley T. Watson.
Okay,
And since this time I have, and on August 13th, it was official that I became the executrix.
okay,
And I've been trying to serve notice to the individuals living there that they had to leave, and they refused. It has been a drug infested dwelling since that time, which continues on to present day and time.
all right. Did you said it continues into the present time. Have you
Yes.
driven by the property or you have
Yes.
personal knowledge that
Yes,
they're still in there?
I have, yes,
As of what date?
as of last week.
Okay,
That was was that Friday? Friday was Good Friday. So that would be the day I drove by.
all right, fine. And to your knowledge, at least 2 people are in the property?
Yes,
Stephanie?
yes, as far as I know, there are many people in that property.
All right, do you know these individuals or they're just,
Transients, no, I don't know them.
all right, fine, thank you. All right, anything else, ma'am?
That's it. I just want the fact that I need to have this order so I can move forward.
All right, I understand it. Just so we're clear, and you made this pretty clear, I think. You never gave them permission yourself to be in the property, anyone?
None.
All right, they just happened to be there when you became the executrix of the estate.
Correct.
All right.
Any prior lease agreements? Any prior lease agreement?
Yeah, I think she's saying, yeah, there was no prior lease agreement or anything like that, was there?
None.
All right, fine. All right, thank you. I'll
Thank
be
you.
getting an order out to you very shortly, like within a day or two, okay?
Thank you so much, Judge.
You're welcome, and I thank you for taking the time to come and state your position, okay?
Thank you
Right.
again. Have a good day.
All right, take care. That ends this proceeding.
Okay.
All right, Ravenel v. Hayes, case number 00094, August term 2021.
Hello?
Ravenel v. Hayes.
Yes, I'm here.
All right, 1 second.
We can get out of this. Oh,
I got Miss Jones here.
Ms. Jones has to get off.
Yeah, I'm gonna kick you out.
Thank you.
You're welcome. All right.
Okay, this is Hayes.
Yes, hi.
Yeah, let me,
Can you hear me?
sure, go ahead, man.
Good morning.
Are you representing yourself?
Yes, sir. I tried to obtain a lawyer, but it costed kind of too much. My husband is here. He the one gave me the house.
Hold on 1 second, ma'am.
See, I knew I needed a lawyer, but it was just not enough. You know, I had too much to do. You were sick and all, you know.
Go ahead, ma'am. So,
Yeah,
Miss Ravenel, right?
yes.
You're representing yourself?
I really tried to obtain a lawyer, but my husband had a UTI that almost killed him. So that threw me behind in the payments. They wanted $2,500 to represent me.
Okay, it's
And
okay, ma'am. Ma'am, it's okay. You're making a knowing, intelligent, and voluntary decision to represent yourself?
Yes, sir.
All right, just hold 1 second. Is there anyone here for the defendants? Tyrone Hayes or Chico Hayes?
I don't know.
No, hold on 1 second, man. Just let them answer. Is Tyrone Hayes or Chico Hayes present, or an attorney for Tyrone Hayes or Chico Hayes? All right, so let the record reflect. It doesn't appear as though Tyrone Hayes or Chico Hayes are present. And just let me double check. Just for the record, I'm looking at the document. It appears as though the two defendants never filed an answer to the plaintiff's complaint, even though both were served on August 7th, 2021. And to your knowledge, they were served. Is that right, Ms. Ravenel?
Yes, they were.
All right, how did you serve them? Just for the record, very quickly.
I had a server from the court server.
Okay, thank you. All right, so why don't you state your position very quickly?
Well, you know, my husband gave me the house real cheap. He sold it to me before we got married because
When was that?
That was around 2019. Was it 19? Yeah, when you sold it to me, yeah. And the people that he had in there was the same.
Oh yeah,
people
hold
that
on.
I'm
We
trying to get
gotta,
out right
we
now.
gotta swear. Ma'am, we're gonna swear you in.
Ma'am, can you raise your right hand, please?
Yes,
You swear
sir.
the testimony you're gonna give to the court today will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
All right. So your husband sold you the property in 2019, and
he sold it to me because he didn't know how to get rid of the ones that was in there. And I had
when you say get rid of the ones, you mean get rid of the occupants?
Yes, sir.
All right.
And so
were those occupants Tyrone Hayes and Chico Hayes?
Well, at the time it was Robert. Tyrone wasn't no problem at the time, so I allowed him to stay.
Who are these people?
They were already in the property when my husband sold it to me. So Tyrone wasn't a problem. He became a problem after his mother died. He got on drugs. He got a big dog.
Ma'am, I'm going to be interjecting just to make sure we make a complete record. I don't want this to take too long. All right. So you said, was it Tyrone who was in the property? You said?
Yes, Tyrone was already
So who was
there.
he? Who was he for the record?
He was a tenant of my husband's.
Okay,
and
fine.
He was a good tenant up until his mother passed away right before the pandemic. And then he got on drugs and he just became unbearable. I can't even go to the property now because he just made my
all right, ma'am, just slow down just a tad, okay? Because like I said, I'm going to be asking you questions so we can have an intelligent record as best we can. All
Thank
right.
you.
So Tyrone was a tenant of your husband's, yes?
Yes.
All right. He had a lease with your husband.
Did he have a lease, James? Did
I'm
Tyrone
asking
have
you,
a lease?
ma'am. You're
No.
testifying.
No, no, he never had a lease.
All right, but
No.
all right. So anyhow, to make a long story short, is your husband going to be a witness there?
Yes, he
All
right
right,
here.
fine. All right. So anyhow, I'm assuming that your husband ended the lease, and he'll confirm that. And then what? Your husband basically was interested in getting them out, right?
Yes, and
All right.
I wound up letting Tyrone stay.
All
I
right.
wind up giving him a lease.
So you
And
gave him, hold on. You gave him a lease?
I was the one gave him a lease.
When?
Yes.
When did you give him a lease?
I gave him a lease in 2020, and it was month to month.
Okay.
And he moved his brother in, and then he said his brother
Is his
moved
brother
out.
Chico? Is his brother Chico?
Yes.
All right. When
Then
did he move
said
his brother in?
He moved his brother in last year, around about December, January, around January.
All right, but you never gave Chico permission to be there, right?
Well, yeah, I did, because he said he was going to pay me.
When?
But when I moved him in January, he said he was going to pay me. He paid me like 2 months, and then he moved. And it's like they moved all kind of people in.
All right.
I couldn't even go to the property. I stopped getting paid during the pandemic. I didn't get anything.
I understand. All right. Anything else, ma'am?
Yeah, well, I tried to work with Tyrone because his mother passed away. I'm a good-hearted person.
Right.
And he tried to get me to do some fraud, like I'm going to go against the government. He wanted me to say that my house was part of the disaster fund.
Right.
And he was wanting me to get sign the money over to him, saying that his property, the first floor, was damaged. And after I told him I wasn't going to do that, he just totally shut down.
All right. When was this, ma'am?
That was about, let's see, I'll say that was in February of this year. He tried to get me to fraudulent the government.
All right, I understand. Do you still have a lease with them, ma'am?
No, sir.
When did you end your lease with them?
Well, I tried to get some money from the government for the rental assistance program.
My question was, when did you end your lease with them?
Well, that's what I'm trying to tell you. I tried to get the money. I thought if I could get some money, I'll let them stay. I'm a good-hearted person.
My question, just answer the question. You said you no longer have a leasehold with them. I just want to know when you ended, in your knowledge.
I didn't end it.
Are you telling me you still have a lease with them?
The reason why I didn't end it, because I was trying to get some money from the government legally, like the rental assistance that everybody was putting in for. I tried to work with him because his mother passed away. And I felt bad because he said that everybody had moved out.
All right, ma'am, I just want to know, I understand that. Did you technically tell them that their leasehold had ended? That's all I really need to know.
Yes.
When? So tell me when. That's all, because we're making, I don't, I say it respectfully. I got other hearings I have to get to.
Sir, I apologize. Basically, I was looking forward to trying to get the rental assistance. So I know.
Just tell me when you ended the lease. That's all I want to know.
Okay, I ended it 2 months ago.
How do you told them you wanted to end the lease?
Yes, I told him that he wasn't paying me.
All right.
And I got a text message where I told him that, it had to end.
Okay. All right. And did you give him a written notice as well, ma'am?
Yes.
Okay. And all right, thank you. Is there anything else you want to add?
Well, I can work with people. I don't know if the government is willing to send me any money.
Well, they haven't yet. So
no, they haven't, sir.
Yeah.
No, they
haven't.
My
point is, your intent is to end the lease. Is that correct, ma'am? You want them out?
Yes, sir. Yes, sir.
Okay,
yes,
thank
sir.
you. And I'm not giving you a hard time or being disrespectful. It's just that, like I said, I don't want to make this more complicated than it is. And your main interest is to get them out the house, correct?
Yes, sir. Yes,
All
sir.
right.
Yes, sir.
And they're not here. They haven't answered the complaint. So you know, I'm trying to help you here. All right.
God bless you.
All right.
God bless
Anything
you.
else? Anything else, ma'am?
It's another case that you gotta hear that's coming up. It's with my husband. It's
Is
coming
that a
up.
separate case?
Yes, sir.
All right, so we'll get back to that. I want to do the attorneys because I think there's attorneys on here. I don't want to keep them waiting.
Thank you,
As it
sir.
relates to this case, we're going to be done now. You did want to put your husband on very quickly as it relates to this case,
James, do you want to say
ma'am,
anything?
ma'am.
Yes, sir. Yes,
All right,
sir.
so just put him on for a second. It's not going to take long,
Okay, say something, James, about the case.
ma'am.
About them being in the
Oh
house.
my
Yes.
gosh, ma'am.
Yes.
What's his name, ma'am?
James Lake.
James Blake. Can you hear me?
Lake, say hello, James.
Hello.
Do you raise your right hand, sir?
Raise your right hand, James. He had a stroke. He can't hardly raise it.
Can he? Does he have the mental capacity to testify to your knowledge?
Yeah, he can testify. He
All
know
right,
he
fine. All right, hasn't affected his memory, right?
No.
All right, sir, can you hear me?
Can you hear him, James?
Yeah.
Do you swear to tell the
Please,
truth? Do you swear affirm to tell the truth and nothing but the truth? So help you God.
Are you going to tell the truth, James?
Yes, yes, yes.
All right. All right, sir, I just want to know, did you hear everything that the plaintiff said?
Yes.
All right. You agree that you sold the house to her?
Yes.
All right. Your intent was to get them out as wells, right? Is that correct?
Right.
You're not
Right.
you're not on the deed, right?
Yes.
You are not on the deed.
Yeah. No, on these.
All right, thank you.
No.
All right, thank you. Teresa, can you hear me?
Yeah, you know, that's what made him have his.
Your name's on the deed, right?
Yes, sir.
All right, thank you.
I thank you.
That
You're
ends
very
this
kind.
particular
Thank you.
proceeding as it relates to this case. And I'll give you my decision very shortly, okay?
Thank you so much.
All right, you can sign off. You as it relates to this matter.
Yes, sir.
All right, thank you.
Thank you.
All right, next.
All right.
Who are the attorneys online? All right.
One judge, and
Good
it's
morning.
regarding the same party, Lake.
How are you, sir?
Good judge, always a pleasure to be before
You
you.
got to get to make it.
Okay, let's you're on Lake, Mr. Turner?
That's correct. It's Lake versus Mann, August term 00101.
All right. All right, that was the next case we were gonna call anyhow. So you're up to bat. So
Okay.
why don't you let me just make sure that you're representing you're representing the defendants though, right?
That's correct. Joseph Bright, who is also online, Judge.
All right, thank you. And that is just Joseph Bright,
That's
AKA
correct.
Joseph Albright.
Yes, he's on the video as Joe. You
All
might
right,
see
thank
him
you.
there with the
Thank
mask
you.
on.
What about the plaintiff? Is the plaintiff present for this hearing?
That would be James Lake, who just testified.
Yes. Yes. Say hi,
Oh.
James.
Oh, okay.
Hello.
But this is a separate case, right, Mr. Turner?
It is.
All right, fine. All right, at least we have everybody here. All right, so James Lake, you're the plaintiff in this matter. So I'm going to give you an opportunity to briefly say a few words, and then I'm going to turn the floor over to Mr. Turner.
This is Joe. Yes, Market Street. Tell him.
They've been in there for 20 months and they paid no rent.
You've already been sworn, sir, in the last hearing. I'm going to incorporate that oath for purposes of your testimony here. Okay, so tell me in one paragraph why you're the plaintiff in this matter.
Tell him, James, why you complaining?
Well, I'm complaining. They've been in my house 20 months and they paid no rent.
All right, which property are you referring to, sir?
Market Street.
Which, Martha Street?
Tell him the address.
Market, is that?
Yeah,
Hold on, ma'am,
5718 Market.
Oh, boy. Okay, ma'am, sir, is that 5718 Market Street?
He said, is that 15?
5718 Market, yeah.
All right. Is that a different property from the previous property you referred to in the last hearing?
Yes.
All right. So what's the issue, sir? you're trying to get someone out of your property at 5718?
Yes.
Just tell me what the situation is.
He been in my house 18, 20 months and ain't paid no rent. They
And
don't
who-
even
when you
talk
say-
to me. They
All right.
don't even talk to me. 20 months, ain't paid no rent.
All right, when you say they, are you referring to Valerie Mann and Joseph Bright?
Yes, tell him yes.
Ma'am,
Yes.
okay.
You gotta listen to the man. He asking you questions.
All right. When did you have a leasehold with them, sir? Meaning a lease?
Yeah, I have these.
When did you enter into a lease with these two individuals?
I gave my lease when they first moved in.
When was that?
A little over a year ago.
All right, so that, roughly speaking, we're talking about April of 2021?
Yes.
Excuse me?
Yes.
All right. Did you submit as part, do you have evidence of your lease?
No, I never had no lease.
I thought you said you just had a lease. You said a year ago you entered a lease into it.
It was a little over a year ago.
All right. So you do have a lease with them. Is that what you're telling me?
Yeah. Yes.
All right. My question to you is, do you have a copy of the lease as evidence?
I can't find it. I don't know where it's at.
All right. Was this a written lease or an
A
oral
lot of
lease?
stuff got thrown around. When I
All right.
had
Was this a written lease or an oral lease?
Yeah, yes.
Yes, what? Written or oral? Sir?
Written. It was written.
Okay. And what type of leasehold was it? Was it month to month or what?
Yeah, month to month.
All right. And how much under the leasehold? How much were they supposed to pay you per month?
700.
Per month. Okay. All right. So when did you end? Did you end the leasehold?
What you say?
Did you end the lease with them?
Yeah, they got the lease.
Pardon?
He said, did you end the lease with them?
I never ended it.
You never ended it?
No.
Why not? I mean, why? So if you never ended it, what are you trying? You want them out though, apparently, right?
I'm trying to get them out of my house.
All right, but did you formally end the lease with them, sir?
Yes.
Well, you just said a second ago you did. So did you or did you not?
Yes.
Yes, what? Did you end the lease or did you not end the lease?
I had a lease. Yes, I had a lease.
Sir?
Did you end the lease? Yes or no? Talk to the man.
Yes.
My question is when? When did you end the lease?
Stop paying.
No, I said when did you formally end the lease?
When did I end the lease?
Yeah, when? When did you end it?
Oh, a year ago.
All right, fine. How did you give them notice?
Yes.
All right, written notice?
Yeah, yes.
All right. By the way, is Valerie and Joseph, are they both tenants on that lease?
Yes.
All right. All right, so even though you gave them written notice, you said?
Yes.
All right, but they refused to leave. Is that what the situation is, sir?
They never called me or talked to me or anything.
Okay. Would you like to add anything else before I turn the floor over to Mr. Turner so he can give me a quick summary of what the defense's position is?
Yeah, what is it?
He had a stroke.
I know.
And behind the stroke, he had a UTI. So there's no way that he could go out there and collect this rent. And
Okay.
they just been taking advantage of him ever since he's been unmobile. Like they got his phone number. They got my phone number. They got his address, but they refuse to see how he doing or drop him any kind of mail.
All right, ma'am. And again, you're his wife, right?
Yes, sir.
Okay.
Legally. I had to marry him. We've been friends over 30 years. He
Okay.
helped me raise my daughter.
Ma'am, because you just give me a little bit too much. First of all, I'm going to swear you in. Do you swear to firm to tell the truth and nothing?
Yes.
All right. You already sworn in the previous hearing. I'm going to incorporate that oath here. All right. So let me just turn the floor over to Mr. Turner very quickly, just to get a summary from him in terms of what the defense's position is, and then I'll take it from there. So, Mr. Turner, I'm going to turn the floor over to you now, sir.
Thank you, Judge. A pleasure. We have here today James Bright, who is a party and on the Zoom hearing. What you will hear from defense, Judge, is there was an answer filed to the complaint. That answer does reference a lease that was entered into by the parties. It's attached as an exhibit in the answer, and there were copies emailed to you. It is signed by James Lake as well as Joseph Bright. The lease speaks for itself in terms of the terms of that lease. Mr. Bright was never given any formal written notice that the lease was terminated. He has been, and he'll testify to this if you would rather hear from him. But I think the court will hear that he has been paying rent, that there was a time when Lake would come by and pick up the rent. And then he was hospitalized, had a stroke, what have you. And the Bright would then try to go to the house, was paying monies to the person who represented themselves as being his wife in cash, and he would never receive the receipt for those amounts. So that's essentially where we are today, Judge. And if you would like, you can swear in Mr. Bright, who is here on the video conference, so he can testify.
So your position is that Mr. Bright has been paying the rent all along, at least?
Yes.
All right.
I mean, he has been paying the rent. Now, the exact amount that might be owing at this point is it's not clear. In fact, this probably shouldn't be an ejectment action. It should be a landlord-tenant action.
Sounds like it. You might be right. But okay. Yeah, so you may be right about that. So let me, just to cut through the chase, ask Mr. Lake, before I let Mr. Turner put on his witness, did you want to put on any other evidence, sir, before you rest your case, and then Mr. Turner can put on his evidence?
What do you say?
You want to tell him anything else about the case before?
My question is, do you have any other evidence? Because you just sort of gave me a summary. Do you have any evidence that you would like to put on very quickly?
He ain't paid no rent. He ain't called me or talked to me or nothing.
Ever since you got sick?
Ever since I've been sick.
All right. Let me, ma'am, can I just ask you a quick question?
Yes, sir.
Just to speed this along, since you seem to be a witness on his behalf. Mr. Turner, you heard in his synopsis what he said as it relates to his client. Did you ever receive any money from Mr. Bright, like for rent or anything like that?
No, sir. No, sir. I told him where we live. I gave him our address. I gave him out my phone number. He never came here at all. He came here maybe one time when I told him that James could not come to him. And when he came here, I talked to him. I said, look, I understand that we're in a pandemic and everybody hurting right now. I said, but the government is giving up money to people for rent, for rental assistance. I told him.
All right, so the bottom line, ma'am, the bottom line is you disagree with Mr. Turner's assessment, right?
Yes, I totally do, for the simple fact.
All right, it's okay, ma'am, it's okay. I heard enough, ma'am, and I'm not being rude. It's just that I'm trying to sort of cut through the chase. So please, I'm not showing favoritism. This could very well be a landlord-tenant issue anyhow, but I'm trying to cut through the chase so I make sure I understand what the issue is before I make my decision. All right, so I'm going to turn the floor back over to Mr. Turner very quickly so he can put on a brief witness, and then I think we'll be done with the hearing. Okay?
Okay.
Mr. Turner, do you want to put on a very brief witness, sir?
Yes. But before I do that, Judge, I would just like to bring to the court's attention that there was another complaint filed after this one involving the same party, same property. It has a different docket number, but all the same issues are involved. I don't know if can I just put that case number on the record? They haven't been joined at that point.
Hold on. Yeah, well, you can. Can you hear me, Mr. Turner?
Yes,
Yeah, you can put obviously the number on the record, but I don't have that case before me, as you know.
I understand. If I just might put that on the record.
Go ahead, put it on the record.
It's Lake versus Albright et al. And it's case number 2111-00660. It involves the same property, the same party. This
Okay.
matter is scheduled in June sometime, but it's the exact same case. So would you like me now to put on Mr. Bright?
Yeah, but you're saying it's actually the exact same case as this one.
That's correct, Judge. And
All right,
you
so
know,
I don't
if
know
you
why
would like to inquire of Mr. Lake or Teresa Lake, or I'm not certain if that's her last name, was there a second filing?
All right. Did you file another separate case, ma'am, or Mr. Lake?
The cases that we filed was in room 220, 296. That's the only case we filed. And we filed them. We thought we were filing them together, but they made me pay 2 different times to get him and Valerie out. So if that's what he's talking about, I don't know how the cases go. I'm not into being an attorney. I apologize. But I can honestly tell you that the only reason why I allowed them to stay is because I tried to work with Mr. Albright, and the only money that he ever gave up was some of the pandemic money. He didn't even give up all the pandemic money. And then on top of it, I got a little note that he gave me with he was going to put what he was going to pay me, but he never paid me.
Are you talking about Mr. Bright?
Mr. Albright stated that
all
he was going to get the government to give me the rental assistance. But as you know, Judge, I'm not
ma'am,
please, can I say this? Please. A lot of them is going to be charged with fraud because they got the money and spent it. They didn't send it to the landlords.
I understand. Okay, Mr. Turner.
Can I answer one question, Judge? If I
Yeah,
might?
sure. Yeah, Mr. Turner, if you don't, yeah, you're welcome to put your question on the record. But I was going to say, if you just want to briefly put on your witness, I think I get the gist of what's going on, and I'm prepared to have enough information to make my decision. But why don't you say what you want to say, and then put on your witness very briefly.
Let me put Mr. Bright on then. Mr. Bright, can you identify yourself for the record? Are you there?
Mr. Bright, can you hear us? Mr. Bright.
He was there, identified as Joe. He's at work, Judge. Is he still
He
there?
probably smoking crack.
Oh, boy.
Would object to that, Judge.
All right. Yeah, also
Hello?
Move to strike. Mr. Here he is. Is this him?
Mr. Bright, yes, Mr. Bright. Can you remove your mask?
Yes.
We're going to call you as a witness now.
Before we start, though, I just want to say my phone is acting up. It's in and out.
Okay, just let your attorney ask the question then, okay? Go, real fast. Go ahead, Mr. Turner.
May he be sworn, Judge? We need to swear him.
Yeah, thank you.
Mr. Bright, could you raise your right hand, please? Do you swear that the testimony you're going to give to the court today will be the truth, the whole truth, and nothing but the truth?
Yes.
All right. Take yourself off mute, Mr. Bright.
No, he's
Oh, is he? Okay, can you hear us?
Yes.
All right, go ahead.
Can you hear me? Yes.
All right, go ahead, Mr. Turner.
Thank you, Judge. Mr. Bright, are you also known as James Albright? Can you hear me?
No,
sir?
that's been a misprint and it's been appearing on all the documents.
Okay, so what is your name, sir? Identify yourself.
It's Joseph Bright, B-R-I-G-H-T.
And where do you live at?
5718 Market Street.
Okay, and who do you live there with?
And my wife, Lorraine.
Okay, and do you know James Lake?
Yes.
Okay, and did you enter into a lease agreement for that property with Mr. Lake?
Yes.
You said you did? Yes, I didn't hear you. Was there a lease agreement?
Yes, I guess.
Okay. And when did you enter into that agreement?
Oh, well, I'm not very good with dates. It's been some years. The date appears on the lease.
Okay. have you ever received written notice that that lease was terminated?
No, I never received notice.
Okay. And have you been paying rent under that lease?
Yes.
Okay. And at some point in time, you became how was that rent paid? Did Mr. Lake come to the house or did you go there?
He had a representative at one time come to pick it up, and then he began coming himself to pick it up.
Okay.
At one time, he stopped coming altogether, and I would come to the house on occasion.
Okay. And were you aware that at some point he had a stroke, became ill?
Yes.
Okay. And did he then stop coming to the house?
Yes, I would believe it's around that time, yes.
Okay. And what happens then in terms of paying rent? What happened after that?
Okay, after that, his wife got in touch with us, and we made an agreement for me to come to their property to make payment.
Did you hear that, Judge?
No, just repeat what you said, please. Repeat what you said.
Slowly.
Okay, after he became ill and he stopped coming to our house to collect the rent, his wife asked me to come to his house to make the payment.
Okay. And is that the person that appears here on Zoom? That's his wife?
Yes.
That's the person that identified herself as, and did you make payments to her?
Yes.
Okay. Did you receive?
At the property, yes. I never seen James at the house.
Okay, I'm saying, when you made payments to her, did you receive a receipt?
Okay, no, at that time, shortly before that, me and Mr. Lake had a verbal agreement because I was out of work for a few weeks and I was short on the rent. I had fallen behind. We had made an agreement that I would pay $400 every 2 weeks with an additional $100 to catch up on the behinds. So I was actually paying $500 every 2 weeks.
Okay. So you were paying that to her now, though, correct?
Yes.
And how are you paying that? What form?
Of cash.
Say again?
Cash.
Okay. Did you ever get a receipt for that cash?
Our receipts were scattered here and there. I mean, there was never a consistent receipt. Every now and then, if she had.
Okay. All right. So, Mr. Turner.
Yes.
All right. I think I get the gist. Only because we're having a lot of problems, as you can see, with the audio. It has nothing to do with you.
Yes.
So I'm trying to. I know the other attorneys are waiting. So the bottom line is, why we still have them more in your position is that there's a landlord-tenant relationship here.
Yes, Judge.
Okay.
And the lease is part of the answer that was filed with the court.
All right.
Signed by both parties.
All right. While you have this witness here, are there any other points you would like to make with regard to the landlord-tenant relationship so we have a complete record?
No, Judge. In the sake of expediency, I would just mention there was another filing, same parties, same action, involving the same property. But that's not here before the court today.
All right.
But your decision today might be dispositive of that as well.
I understand. All right. And Mr. Bright, you're still in the house, correct?
Yes.
All right. And you're still paying rent to him?
No.
Okay.
For some time, and
What?
You're breaking up,
okay,
Mr.
for some
Bright.
time, I've even tried to call her number. That's just to do the property. I'm sorry.
All right. So when did you stop paying rent?
Oh boy. I would say it's been at least 5 months since I've.
And I don't want to interfere with your attorney because he's representing you. He has specific questions, but just tell me why you stopped paying rent.
Because again, I've gotten, there was no way to get in touch with anyone. If I call James Lake's phone number, it goes to voicemail, no response. I call her number, no response.
Judge, in that regard, can I ask a question of?
Go ahead, sir.
And that is, Teresa, I forgot your last name. If you could say that for me.
Robin Hall.
Robin Hall, Miss Robin Hall, do you recall myself calling you regarding this matter? I can't hear her, Judge. I think she's
muted.
muted.
She's muted, Your Honor.
Yeah, Teresa, unmute yourself.
Hello? Can you hear me
Teresa,
now?
I'm asking a question of you. Do you recall me calling the attorney for Mr. Bright, Dennis Turner, calling you and me asking you about this matter, and you were saying we're going to let it play out as it might play out? Do you recall that?
I don't recall you calling me.
And yes, in the court.
In the courts, I said that I wanted it to play out in the courts because I know he owed James a lot of money, more than 5 months.
Okay, but I'm just saying there was a conversation and you said you wanted to let it play out in the courts, correct?
I said, if you was his attorney representing him, I needed to get an attorney representing me, correct?
I don't recall that.
Well, I don't recall
But there
what you
was a
said.
conversation.
All right. All right. So anything, Mr. Turner, was there anything else that you wanted to point out for the record before we end this proceeding? Because I think I pretty much get the gist of what your position is.
No, Judge, I think we've concluded.
All right.
Defense rests.
And again, there were no other points that you wanted to put on the record with relationship to the paperwork you filed?
Well, just that there is, based on the pleadings, there should be judgment for the defendant because they said that there was no lease in the pleadings. And in fact, there was a lease in the pleading.
Okay.
But this is a matter that probably should be in landlord-tenant court, not an action for ejection.
I understand. Okay. All right. Plaintiffs, do you have any final words before we, and you rest, Mr. Turner?
I do.
All right, thank you. You submitted all your, if there are any documents, you submitted them into the record?
Yes, Judge.
All right, thank you.
Yes, I sent you an email though.
All right,
so
thank you.
Okay.
Just for the record, do you want to articulate what those documents were, if there were any, just so we have it on the record?
Yeah, it is a copy of the landlord-tenant lease between the parties, parts 1 and part 2 that were emailed to you. They're also a part of the exhibit in the answer to the complaint that was filed. And that document is both signed by James Lake as well as Joseph Bright.
Okay, thank you. All right, plaintiffs, do you want any parting words before we end this hearing? All right, let the record reflect that we have now completed this hearing. I've asked the plaintiffs if they wish to say anything as given a closing. They already gave their closing remarks, but I wanted to give them an opportunity to say one final thing. They're not responding. So that officially ends this hearing, and I'll get my decision out to you within the next day or two, okay?
Thank you, Judge. That concludes my business. Maybe we be excused?
Yes, take care of yourself. Good seeing you.
Thank you. You as well.
Bye. All right, next.
Next case, Wade v. Raming, case number 00183, August term 2021. Wade v. Raming.
Okay. Mrs. Wade, are you present?
You need to unmute yourself, ma'am.
Can you hear us?
She can hear us.
I can hear you. Can you hear me?
Yeah, now I can hear you. Okay.
Yes, sir.
Do you have an attorney?
No, sir.
All right. What about Jeffrey Roman?
Raming.
Right? How you pronounce it?
I think it's Raming.
Ramen. Are you present? It's an attorney who's representing Mr. Raman. Again, Jeffrey Raman or his counsel, are you present?
No, doesn't appear to be.
Okay. All right. Let the record reflect that it looks like Jeffrey Raman was served on August 17th, 2021, according to the docket. And then there's a Jane Doe and John Doe. Jane Doe was served on August 17th, 2021. And there's no indication on the docket about John Doe. Although it's possible that Jeffrey Raman may be John Doe, I'm not sure. But either way, ma'am, why don't you just quickly state what your position is? You're here. Were you sworn? Were you sworn yet?
No, sir.
Ma'am, can you please raise your right hand and state and spell your name for the record?
My name is Patricia Wade.
And can you spell that, please?
Patriciawade.
All right, and do you swear that the testimony you're about to give to the court today is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. So this shouldn't take too long. Just explain to me why you're here today, ma'am. Obviously, you want to, there's people on your property you want to eject, right?
Yes, sir.
So go ahead, just make a quick record for me.
Okay, I purchased the property in November from Dana Stewart. I went down to
November of when?
The 24th, 2020.
And what's the address?
5016 West Style Street. 5016
West
Styles Street.
Stiles.
Yes, sir.
Okay, in Philadelphia. And what happened?
Everything went through pretty well. I went and had got the deed transferred over to my name from a Coleman Wise, and I purchased the property for $5,000. I was presently living in New York, and start moving in some of my stuff, and it was a group of people that was there that had broke my lock, and it was a horrible situation. The customers had to come, and they told us
I didn't hear the last thing you said. The very last thing.
The cops had to come.
Oh, I see.
Because they had broken my lock. So then
when you say they broke your lock, who are you referring to, man?
it was Jeffrey, I'm sorry, Jeffrey Roman, and some people I don't know. So that's a come I had James, though cops came, and then they told us that during the COVID.
I'm gonna, ma'am, if you don't mind, I'm gonna slow you up just a second, just so that we can get the information on the record. Do you know Jeffrey?
No.
All right. So go ahead. Why don't you finish?
They told us that we couldn't we showed up the deed paper. I showed them the deed paper, and Jeffrey showed him some ID.
You're talking about the police, right?
Yes.
All right. And when was this again?
I don't remember.
Roughly speaking, give me a time frame. If you can.
Doing is around, let me see, December, January
Of?
2020.
Well, you purchased the property November 24th, 2020. So this must be 2021 then.
December 2020, January 2021.
This was right, all this happened like right after.
Right, exactly.
Like, okay.
Okay, all right. So go ahead, finish, man.
And so, when I came down, they was in there. I couldn't get them out. I went to the court to have them ejected, and it was procedure, and I was doing that ever since. And so this is the court hearing that I'm having right now today.
Okay. All right, thank you. Just for the record again, Jeffrey, Raman, Jane Doe, and John Doe, they're not present at today's hearing, and Jeffrey was served again on 8/17 and John Doe on 8/17. I don't believe that they answered anything to my knowledge. Okay. Anything else, ma'am?
No, sir.
All right, so you would like to have them ejected so that you can peacefully take over the property, right?
Yes.
All right, we'd like to add anything else?
No, sir.
All right. And you made a knowing, intelligent, voluntary decision to represent yourself today?
Yes, sir.
All right. All right. 1 second. All right. Thank you, ma'am. I think I have the information I need. I'll be giving you my order in a couple days. Okay.
Thank you so much.
You take care. Good luck.
May I ask you, how do I get the order?
We're going to send it to you. We have all your email information, right?
Yes, sir.
All right. Thank you.
Thank you.
Take care of yourself.
Thank you, you too.
All right. Next.
Okay, Miles v. Ross, case number 00626, August term 2021, Miles v. Ross. Anyone here for Miles v. Ross?
Yes.
Okay, who, is Anthony Miles Jr., is he present?
No, I haven't seen his
All
name
right, what
come
about,
up.
is there an attorney present for Anthony Miles, the plaintiff?
I didn't even see him in here.
All right, so what about the defendants? Michelle Ross,
Michelle Ross is in the hospital and unable to
who's
speak.
speaking?
This is Joyce Salazar.
This is Joyce Salazar.
Oh, okay, fine. Can you put yourself on the screen? Ma'am?
Yes, I'm trying to get there.
Okay, there we go. All right. All right, so ma'am, you're one of the defendants, right?
Yes.
All right. And there's appears to be 4 defendants. Joyce, you, obviously I'm speaking to you, and then there's Michelle Ross.
Michelle Ross is currently in the hospital and she has tracheotomy in her neck and she's not able to speak.
All right, what about Michael Gonzalez?
Michael Gonzalez is incarcerated and he's been left the property.
All right, and then Michelle Ross.
Lachelle Ross, she's at work and is unable to attend.
Okay. So you're the only ones here. All right. And Anthony Miles is not here, right?
No.
All right.
Well, that's it then.
Did you ever? Did she ever file an answer?
It's irrelevant.
Yeah, yeah. Okay, well, thank you.
So you're not
Before,
gonna
while I
hear me?
have you, man, we're only gonna be another minute. What's your position since you're here?
My position is I don't understand why he's trying to throw me out. He brought me in to take care of his wife, Michelle Ross.
Okay.
Because she's disabled. She's been disabled since they were married in 2007. And to help take care of his daughter, which is Lachelle Ross. And I don't understand why he's all of a sudden ejecting people, and how is he able to do that when that's marital property. Him and his wife bought it after they were married, and for some strange reason he ended up with a divorce with no signatures because she didn't sign anything.
All right, so you're the only you're in the house, right? Obviously.
Yes, I'm in the house and his daughter Lachelle is in the house.
Okay, gotcha. All right. And when's the last time you saw Anthony?
We haven't seen him since he moved out in July of 2021.
All right. You said it was marital property. Have you seen his wife?
His wife is in the hospital. I see her almost every day.
I'm sorry. What's her name again? What's her name?
Michelle Ross.
Oh, so that's his wife.
Yes.
Okay, I understand. Okay. All right, gotcha. Okay. All right, ma'am. Well, he's not here today, so thank you. Okay. Did we swear her in? Yeah. Just let me swear you in for a second. Do you swear affirm to tell the truth and nothing but the truth, so help you God?
So help me God, I swear.
All right, you just said what you said. I'm going to incorporate by reference what you just said now that you're sworn. And I think that ends this proceeding. He's not present anyhow. Okay.
Mm-hmm.
All right. You have a good day. Okay.
Thank you so much.
All right. Thank you.
All right. Bye-bye.
All right. So that leaves what?
That leaves the last one, Barry v. Eason. That's the big one.
All right. Hold on. All right. Finally, we got Barry versus Eason.
Case number 01210, December 2020 term.
Okay. At the party, Miss Ella Berry, are you present?
Your Honor, good morning. My name is Brett Datto. I previously represented Ms. Berry. She has passed away. Substituted of record on January 21st of 2022 is her granddaughter, Tiana Wilder, who is now the plaintiff in this ejectment action. She is present on the screen.
And that's her granddaughter?
Yes, sir.
All right, thank you. My apologies for keeping all the attorneys waiting on this one. If I when they give me all these files, it's sort of hard to figure out who's who. And had I known, I would have started out with this one because I don't want to keep the attorneys waiting unnecessarily. All right. So anyhow, when did Miss Barry die?
Ms. Berry died, Your Honor, on July the 10th of 2021.
All right. Thank you. All right. And what about Jerome Eason? Are you present?
Yes, sir.
All right. All right. Thank you. And you have an attorney, right?
Yes, sir.
Who's your attorney?
Ronald Fischera. I represent the defendants, Your Honor.
All right. How are you, sir?
Fine. Thank you.
All right. Thank you. All right. First of all, we're going to swear in all the witnesses, and I'm going to go back to the plaintiff's attorney so he can just give me a brief synopsis of what his opening is going to be. And then I'll get a brief synopsis and opening from the defense attorney. So if all witnesses could just raise your right hands, please.
Do you swear the testimony you'll give to the court today will be the truth, the whole truth, and nothing but the truth?
I do.
All right. Same
I
thing.
do.
All right. Thank you. All right. So, Mr. Dado, I'm going to go to you first. Can you please give me a quick opening in terms of what your position is as it relates to this case?
I can, Your Honor. Again, good morning. Your Honor, just briefly, though, before we get into my opening, when you asked Mr. Easton to raise his right hand, I saw at least 5 hands. So apparently there's other people in the room, and I think they should be identified and separately sworn in.
Yeah. We'll identify, of course, the witnesses as the attorneys present them. However, all those who raise your hands, can you just identify yourselves for the record, please?
Hello, I'm Jasmine Easton. I'm Jerome's daughter.
Okay. And who else?
And I'm Vivian Easton, also Jerome's daughter.
All right. Are you going to be witnesses?
Yes, Your Honor. They may be.
Thank you, sir. All right. So now I go back to you, Mr. Dado, if you don't, or Dado, if you could quickly give an opening in terms of what your position is relative to your client.
I can, Your Honor. And again, thank you for your honor's time. Your Honor, this is a complaint in ejectment where Tiana Wilder has now the legal standing to bring this claim on behalf of her deceased grandmother. On January 28th of 2022, Ms. Wilder was substituted under Rule 2352 as the party plaintiff in this particular case. By way of just brief background, Your Honor, we're here with regard to a property located at 4941 Monument Road in Philadelphia. Your Honor, the complaint in ejectment was filed back in December of 2020. January 21st of 2020. I think it's important for the court to know and understand that there were 5 named defendants at that time. Mr. Eason is the only one who has filed an answer in this case. The other 4 named defendants, and their names are Regina Davis, Chase Eason, Jasmine Eason, and Vivian Eason, have all been subjected to a default judgment, which has resulted in a judgment of possession entered on the docket on February the 8th of 2021.
All right, and who, Regina, Chase, Vivian, and who else?
Regina, Chase, Jasmine, and Vivian all have defaults against them.
All right. Okay.
And importantly, Your Honor, as I get into it a little bit, and I know you want to be brief, Mr. Eason's answer that was filed in this case asserts no affirmative defenses, and I'll tell you why that's relevant as we get into it. Your Honor, just briefly, the subject property 4941 was acquired by Templeton Foxworth and his wife, Barbara Foxworth, in December of 1974. Mr. Eason is the nephew of Barbara Foxworth. Barbara Foxworth passed away on September the 5th of 2014. She had a will.
I'm going to just slow you down just a second. All right,
Yes, sir.
Jerome is the nephew of Barbara Fox
Worth.
And she passed when?
September 5 of 2014.
All right.
Ms. Foxworth had a sister, Ella Mae Berry, who was the plaintiff in this case. Ms. Berry was appointed by the court as her executrix, the executrix of her sister's estate, on November the 13th of 2015. What's important about that, Your Honor, is back at that time, following the death of Mr. Eason's aunt, Barbara Foxworth, he filed a caveat with the Philadelphia Register of Wills. That caveat was ultimately dismissed by way of a decree that was entered by the court, and I have the exhibits that I've uploaded, that has been dismissed by the court by way of a decree on November 10th of 2015. So the will of Barbara Foxworth was admitted into probate over the objection of Mr. Eason's caveat, which was dismissed. After the estate was probated, Your Honor, and this is what brings us here today, Ms. Berry, who rightfully was the sole heir to Ms. Foxworthy's estate, obtained title to the property, to 4941. And
that's Ella.
That's correct.
All right.
And the deed was recorded in Ella's name on June the 1st of 2016. So from June 1st of 2016 to present, the record owner of 4941 is Ella Mae Berry. Mr. Eason has never had title to the property, has never had a lease to the property, and has no interest in the property otherwise. The property under Pennsylvania estate law rightfully goes to the sole heir of Ella Mae Berry's estate, which is Tiana Wilder, who is now duly appointed as the administratrix of her deceased grandmother's estate. The defense in this case, Your Honor, is that apparently there's two defenses. Again, not raised by way of new matter, but I think it's important to highlight. One is that the deed that I referenced was allegedly forged. That defense, if Mr. Eason was to claim that as a defense, A, needs to be raised by new matter, and B, would have needed to be raised in the estate of Barbara Foxworth. And he had the opportunity when he filed the caveat, but he forewent that, and the estate was probated. The will was admitted into probate, and subsequently the deed was executed of record. So any alleged issue of forgery is waived. The second defense, Your Honor, that the defense has put forth is that they had an oral agreement with, they meaning Mr. Eason and his family, the defendants, had an oral agreement with Barbara Foxworthy to remain in the property. And as the court knows, that would be barred by either the dead man statute, hearsay, or would otherwise needed to have been raised as a defense in Barbara Foxworth's estate. So for those two reasons, Your Honor, we are here today because we are the only one who has superior rights and titles in the subject property. And we would ask that a judgment for ejectment be entered, not only as to obviously the four defaulting parties, but as to Mr. Eason, who has no defense in this case. Thank you.
All right, so in the second defense, you were saying that Easton, the defendant, is alleging that he had an agreement with the deceased, and as far by who's now, and that is waived by the dead man statute, a hearsay, et cetera.
And also waived by the fact that he attempted to raise that as an issue with the Register of Wills, and he abandoned that cause of action.
Okay, fine.
In 2016, which resulted in the decree.
All right, thank you. Anything else?
No, Your Honor. I have Ms. Wilder, and I'm prepared to present testimony first of Mr. Eason and then of Ms. Wilder, but Mr. Fitzgerald may have an opening.
Right. All right, defense counsel, do you have a brief opening?
Yes, Your Honor. I think plaintiff's counsel has outlined the basic premise of the case. However, what's missing here is that the defendants, Jerome Eason and his daughters, took care of and cared for Barbara Foxworth and her husband, Templeton Foxworth, since 1995. They then, in 2014, I'm sorry, 2009, moved into the property with Miss Foxworth after her husband died, and Jerome Eason and his two daughters took care of Barbara Foxworth. During all those years, from 1995 through 2014, and then through 2014 up until the present time, the defendants have paid all of the bills with regard to the property, the utilities, including the taxes. And in fact, at the time that the probate of the will was going through, there was notice of a sheriff's sale of the property for back taxes, which Mr. Eason and his family paid to the city of Philadelphia and the state of Pennsylvania. So I have sent, Your Honor, the breakdown of the amounts that were expended by the defendants in the care of Miss Foxworth and her husband, and in the maintenance and the care of the property. What the defendants are seeking here, Your Honor, is equity with regard to this decision that Your Honor has to make with regard to their injectment. So when counsel says that there is their testimony with regard to an agreement with Miss Foxworth pertaining to the property and their right to stay there is barred by hearsay in the dead man statute. Your Honor, basically what we have here now, however, is Your Honor can take judicial notice that a contract did exist between the defendants and Miss Foxworth. They were asked to move into the property. They took care of the plaintiff and her husband. I'm sorry, took care of Miss Foxworth and her husband from 1995 through 2009, and then through 2009 through 2014, they moved into the property, and they have stayed in the property since 2014. And during that time have expended thousands of dollars for the upkeep and the care of the property, as well as the personal services rendered to Barbara Foxworth and her husband. Now, this money that was expended by them, according to them, was part of an agreement between Miss Foxworth and them to assist her with her care and treatment, and which would allow them to stay in the property. Now, if they are to be evicted or removed from the property, it is their claim that they have a right to be reimbursed for all the money that they have expended to care for Miss Foxworth under that agreement, because there was an offer, acceptance, and consideration for that agreement. And we have the proof of that through all of the bills and the expenditures made by the defendants, and for all the maintenance of the property, which we also have proof of, which would be the utilities, the landscaping, the repairs to the property, and the taxes that they have paid. So if they are to leave the property, the plaintiff would be unjustly enriched by all of the expenditures and the money that was spent by the defendants for the care and treatment of the deceased Barbara Foxworth, her husband Templeton Foxworth, and the care of the property. And that has been presented to you by way of email, Your Honor, and it was also outlined in our brief to you.
Okay. All right, thank you. I'm going to get right into the testimony in a second. I'm going to give the plaintiff an opportunity to put on his testimony. But before I do that, I'm going to be a little unorthodox and go back to the plaintiff's attorney and just ask you quickly, what is your response to defense counsel's argument about unjust enrichment?
Couple responses. First of all, Your Honor, there is no judicial notice of an oral contract, as the court is well aware.
Well, I know that, but I'm talking about the unjust enrichment.
There are two things. One, there is no counterclaim in this particular case for unjust enrichment. Number one. Number
Your Honor,
two,
if I may respond to that.
No, wait, he's talking, so I'll give you a chance
I-
to
I'm just
respond. Just
asking.
let him finish.
Thank you.
Go
Number,
ahead, sir.
number two, and more importantly, if any claim existed, it would have been a claim by Mr. Eason against his deceased aunt, Barbara Foxworth's estate, not 7 years later against Tina Wilder, who now has rightful possession to this property.
Gotcha. Okay, thank you. Mr. Defense Counsel, do you wish to respond?
Well,
very
Your
briefly?
Honor, just so we're clear, when the will was being probated, first of all, I did not represent the defendants at that time. I did not come into this case until 2021. They were represented by a previous counsel who did file certain documents in that matter, who then withdrew as their counsel. Mr. Eason and his family did not follow up because they were unaware of what they had to do with regard to the probate of the will. So that the issues with regard to the estate were not undertaken by Mr. Eason and his family. With regard to a counterclaim, before I entered into this case, Your Honor, the plaintiff, the defendants were acting pro se. They filed an answer to the complaint, and while there is not any new matter, they do have and have always and I have as their counsel notified counsel for the plaintiff that there were claims outstanding with regard to the money expended and for the care and treatment of Ms. Foxworth and the maintenance of the property. So the fact that they did not follow civil procedural rules technically as pro se defendants should not undercut their defense, because, Your Honor, we can at this point ask Your Honor to allow the defendants to adjust their answer to the complaint and add the new matter. And because we can use the pleadings and the value of the documents that I have presented to you as part of that defense. Your Honor, the key here is that while there was an estate from Ms. Foxworth, which was taken over by Ella Mae Burry, her sister, who then passed away and is now taken over by Tiana Wilder, who's the granddaughter of Ella Mae Burry. The fact remains that this property has been maintained and taken care of, and all the bills have been paid, all the taxes have been paid, all the utilities have been paid, the upkeep has been paid, the landscaping has been paid, everything has been paid by the people that are living in there. And all of that was based on the fact that they were caring for Ms. Foxworth, who allowed them to move into the property. This cannot be ignored by the court simply because the pro se defendants failed to follow civil procedural rules with new matter.
Okay. Thank you. Plaintiff's counsel, put on your evidence.
Yes, plaintiff calls Jerome Eason.
Yes.
Mr. Eason, could you raise your right hand, please? Do you swear the testimony you're about to give to the court today will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Good morning, Mr. Eason. My name is Brett Datto. I'm representing Ms. Wilder. You are presently residing at 4941 Monument Road, correct?
Yes.
And you are residing there with Regina Davis, Chase Eason, Jasmine Eason, and Vivian Eason. Is that correct?
Yes.
And you are not on the deed at that property. Is that correct?
Yes.
You have never been on the deed at that property. Is that correct?
Yes.
You do not have a lease to maintain any type of leasehold interest in that property. Is that correct?
No.
You have a written lease.
No.
Okay. Now, you have lived in that property since 2009, correct?
Yes.
And you're aware that that property was previously owned by your aunt, Barbara Foxworth, correct?
Yes.
And Ms. Foxworth died on September 5th of 2014, correct?
Yes.
And when she passed, she had a sister, Ella Mae Berry, correct?
Yes.
And you're aware that your Aunt Barbara had a last will and testament dated August the 1st of 2014, correct?
Yes.
And Your Honor, the will of Barbara Foxworth has been uploaded as an exhibit. Do you need me to separately mark it for purposes of the questioning?
Yes,
And Your Honor, can I do that by share screen or how I want to show it?
that's fine.
Thank you.
Your Honor, if I may, I think I can assist the court in its time here. The defendants concede that the will was probated. The defendants concede that the deed does not have their name on it.
Okay,
The defendants did also concede that at the time that the will was probated, they did not participate in the any hearings with regard to probate because their counsel had withdrawn. So to the extent that we need to put in all these documents and have testimony with regard to that, we're conceding that. What we're not conceding is the fact that the estate of Ms. Foxworth is going to be unjustly, and the following estate of Ms. Berry will be unjustly enriched by removing my clients, the defendants, who expended hundreds of thousands of dollars with regard to this property.
okay. Counsel, to the extent that defense counsel stipulates, as to those
Understood.
exhibits, that's fine.
Understood. I understood. Your Honor, let me just put into the record just to fine tune what.
And by the way, Your Honor, those exhibits were sent to you by Mr. Dotto in his bench brief.
Yeah, and I have it, that's not the issue so much as I just need to make sure we make a record here. So go ahead, counsel. Counsel said he would stipulate to the extent we can stipulate to some of this evidence, that's fine with me. But go ahead and
Thank
put him in the case, counsel.
Thank you, Your Honor. Mr. Eason, just so we are clear that you are aware that Ella Mae Berry was granted letters of administration to administer your Aunt Barbara's estate, correct?
Yes,
And we'll mark that as P6. And you're also aware, sir, are you not, that you filed a caveat objecting to the probate of your aunt's will? And you did that, I'll show you right here, on November the 25th of 2014. Do you see that?
yes.
And
But they was,
your name is here, Jerome Ronald Eason, as nephew of Barbara Foxworth, correct?
yes,
And then you're aware that after you filed that caveat, the Philadelphia Register of Wills entered a decree or a court order that dismissed your caveat, correct?
yes, but that was due under influence of counsel didn't tell me that I had a second court date.
Okay.
And
Sorry.
go ahead.
But nevertheless, since November 10th of 2015, when we're looking at Plaintiff's Exhibit 7 here, when the Register of Wills dismissed your caveat, you have done nothing by way of filing anything to claim credits for any alleged monies due from your deceased aunt's estate, correct?
Well, I can I understand the question really, because I'm the one that made sure that this property was still here, even though the other side did not even attempt to pay anything on this property. And it was getting ready to go up for share sale, and I had to stop it because obviously they didn't care about it. All they was worrying about was just collecting my aunt's money.
Understood, sir. My question was, did you ever take any further action to claim these expenses in connection with your deceased Aunt Barbara's estate?
Well, I tried, but court is too expensive for me. The other side had more money than me to be able to do more than I did because I had to expend my resources on the property and maintaining my lifestyle too.
Okay, but can we agree, just so we have a clear record, that you never filed any claims for expenses in your deceased Barbara's aunt's estate, correct?
I never had a chance.
Okay. And then you're aware that after your aunt died, that the deed to 4941, which we'll mark as P3, was deeded on April the 2nd of 2016 between your aunt's estate, Ella Mae Berry as executrix, and Ella Mae Berry became the title record owner of that property, correct?
Yes.
Okay. And you've seen that deed before, correct?
Okay. Say it one more time.
Yes.
Say it one more time.
You've seen this deed before?
Yes, I guess so. Yes.
Okay. And since 2016, when this deed was filed of record, did you ever file any claims against Ella Mae Berry saying that any monies were owed to you as a result of your care of Barbara Foxworth?
Well, she knew that. She knew she was supposed to take care of me.
Did you ever
But she
file any
decided-
claims? I'm sorry, sir.
No, but she decided that she didn't want to recognize my side at all.
My question is, did you ever?
Your Honor, the claim is being made now.
Did you ever file any claim while Ella Mae Berry was alive, asking for any type of?
Your Honor, we made the
Excuse me,
claim
excuse me,
while Ella
excuse
Mae
me.
Berry was alive.
Go ahead, counsel. What were you saying? I didn't hear you. Defense
We
counsel.
made the claim while Ella Mae Berry was alive.
Okay. Go ahead. You'll have a chance to put things in context when it comes time for you to question them, counsel. Go
I
ahead.
understand.
One plaintiff's counsel, continue, please.
Thank you. Mr. Eason, after you were served with the plaintiff's lawsuit, you filed an answer in this case. Do you recall that?
Yes, I guess so.
Let's have this marked as plaintiff's exhibit number 2. Is that your signature there?
I don't see anything.
We don't see anything.
It's not on the screen, counsel.
Oh, I'm sorry. It would help to share the screen. I apologize. Okay, my apologies, sir. Is that your signature on plaintiff's exhibit number 2, which is the answer in
Yes.
this case? Okay,
Yes.
okay. And let's see how I do this. And you also verified that the answers were true and correct under penalty of perjury, correct?
Yes.
Now, your answer in this case does not assert any defenses, does it? It's just an answer, correct?
Yes.
Your Honor, I'm going to object to that question. It's calling for an expert opinion. He's not an attorney.
All right. Thank you. I will sustain the objection because the way it was phrased, it is a legal conclusion. Go ahead. Next.
Sure. Your Honor, that's all the questions I have of Mr. Eason at this time.
Okay. Defense counsel, do you have questions?
Your Honor, I'm going to withhold my questions until it's our turn.
Okay. Thank you. That takes care of this witness. Next plaintiff, next witness or evidence?
Plaintiff calls Tiana Wilder. She's been sworn, Your Honor.
Okay, she's been sworn.
Yes, I believe we did.
Yeah, did we swear you in, Miss Wilder? Okay.
Were you previously sworn, Tiana?
Yes, yes, I was.
All right, put yourself on the screen.
Can you see me?
Yeah, now I can.
Okay.
Ms. Wilder, would you please introduce yourself to His Honor and tell us where you live, please?
Yes, Your Honor, I'm Tiana Wilder, the granddaughter of Ella Mae Berry, and I reside in Egg Harbor Township, New Jersey.
And you said that you were the granddaughter of Ella Mae Berry. When did Ms. Berry die?
She died July 10th at 2021.
And at the time that she died, did she have a will?
No, she did not.
Have you since been appointed by the Register of Wills to act as the administratrix of Ella Mae's estate?
Yes, I have.
And have you since been substituted as the party plaintiff in this case?
Yes, sir.
At any point in time from 2016, when your grandmother Ella Mae acquired title to the property, up until today, did Mr. Eason or any members of his family ever make any demand upon you, or to your knowledge, your grandmother, for any type of alleged expenses that they were paying?
No.
Are there any other heirs or descendants of Ella Mae's estate to your knowledge?
No, sir.
You're the sole beneficiary of her estate?
Yes, sir.
That's all the questions I have.
Questions, counsel?
Yes, Ms. Wilder, at the time that Ella Mae Berry was alive, were you aware that there was litigation between her and the defendants?
Yes, sir.
Yes. And were you aware that the defendants had sent documentation to plaintiff's counsel representing Ella Mae Berry that there were claims for expenditures and expenses for the maintenance of the property and the care and treatment of Barbara Foxworth?
No, sir.
You were not made aware that counsel received documents from defendant's counsel with regard to those claims?
I don't recall.
Okay. After Ms. Berry passed away and you entered in as the substitute plaintiff, were you made aware that the defendants had sent documentation to your counsel that the defendants had claims for expenditures for maintenance of the property and the care and treatment of Barbara Foxworth?
Yes.
No further questions.
Okay, any redirect?
No redirect.
All right, thank you. Plaintiff, next witness or piece of evidence?
That would be it, Your Honor. The plaintiff would rest with the admission of the exhibits that I previously referenced.
All right, thank you. Defense
Thank you.
attorney, do you wish to put on some evidence?
Yes, I'm going to call Mr. Eason back to the stand.
Okay,
Mr. Eason, remember you're still under oath?
Yes.
Okay, so Mr. Eason, let's provide the court with some background here. What is your relationship with Barbara Foxworth?
I'm a nephew.
Okay, did you at some point in
You're what?
time?
I'm sorry, I didn't hear you.
I'm a nephew.
Oh, nephew, thank you.
Okay. At some point in time, were you and your relationship with Ms. Foxworth, did you begin to take care of and provide personal services to Barbara Foxworth?
Yes, 24 hours a day.
Okay, and did this happen back in 1995?
Yes.
Okay, did you also take care of and provide personal services to Templeton Foxworth, Barbara Foxworth's husband?
Your Honor,
Yes.
I'm going to object to this. The issue, as far as I see it, Your Honor, with all due respect, is if there was any claim, then the claim for services and care was against Ms. Foxworth's estate. And the defense has conceded that they filed a caveat, that the decree was entered, the will was entered into probate. So whatever happened before the administration of Barbara Foxworth's estate is irrelevant for this court's determination.
Your
Okay.
Honor, that's, may I
Go ahead.
address that, Your Honor?
You may respond. Go ahead.
Your Honor, the fact that the defendants did not file the proper documents during the probate of the will of Ms. Foxworth was simply because they were not represented by counsel at the time. When this ejectment process began, the defendants immediately, through me, provided plaintiff's counsel with all the documentation necessary with regard to the claims and the maintenance and care of Ms. Foxworth. As a matter of fact, Your Honor, at the time that all of this was happening back during the probate process, that was the entire cause of action that was being undertaken by Mr. Eason and his family. It all had to do with the fact that they were living in the property and they had been caring for Ms. Foxworth within that property with Miss Foxworth. So when Miss Foxworth passed away and Miss Berry came in and claimed that she was now the heir of the entire estate, it was unfortunate, but the Eason family were unable to make the proper defenses and raise the proper issues due to their finances. However, the court must consider that this is unjust enrichment on the part of this estate, because despite the fact that Miss Foxworth passed away and Miss Berry became the administratrix and the heir, while she was alive, all of the claims that the defendants are now making were being made against Ella Mae Berry as the administratrix of the estate of Barbara E. Foxworth. We can't forget that fact. Just because Tiana Wilder is now in for Ms. Berry does not abrogate the fact that at the time that this issue came up, Ms. Berry was representing the estate of Ms. Foxworth, and that's who this claim is against. My clients are asking for equitable consideration for all of the money and expenditures they spent. They can't be thrown into the street after they spent hundreds of thousands of dollars to maintain a property that is now going to go back to the plaintiff, and they're not being reimbursed. The fact that technical issues were not raised under civil procedure or probate law by pro se defendants does not abrogate the fact that they have an equitable right to be reimbursed and not be thrown in the street with losses of $100,000, making the plaintiff become unjustly enriched by their services.
Okay. All right.
Brief response, Your Honor. Very
Okay.
brief.
Sure.
Your Honor, if you look at defense counsel's bench memorandum that he submitted yesterday, and I think this is dispositive and rules on my objection, this is defense counsel's bench memorandum yesterday. The defendants concede that any issue regarding the validity of decedent's probated will has been determined and the appeal period has expired. That, Your Honor, unfortunately for the defense, the ship has sailed. If they had claims against Barbara Foxworthy's estate, they failed to take action. There's no equitable or other legal principle to now, 7 years later, try to unravel what should have been done then, and the court should sustain my objection and not allow for any testimony or evidence on this particular issue, especially since it's also not a claim in this particular case.
No, Your Honor, it is a claim in this case because the original complaint was from the estate of Barbara Foxworth. That was the original complaint. The original complaint, the complaint is not the Berry estate, it's the Foxworth estate. The money that was, because they did not make this claim at the time of probate, does not abrogate the fact that the estate of Ms. Foxworth and her heirs are being unjustly enriched by the expenditures of my clients. It's simply a matter of equity and clearly, and let me rephrase it this way. If Your Honor were to find that this complaint cannot be made, well, then we would have to file a separate complaint after this hearing against the estate, because my clients have no recourse under the law for all the money that they've been spending while maintaining the property. And we are willing to concede that there may have been rental expenditures due and owing to the owners of the property, which can be offset against the expenditures that they paid to maintain the property. And that's all in my bench brief, and all has been sent to the court. So counsel who keeps referring back to the fact that the defendants at the time were pro se and failed to, and the reason we conceded the probate and the fact that the appeal period passed is we have to concede it. That's what happened. And we're not arguing that. What we are arguing is that this complaint is from the estate of Barbara E. Foxworth. And this claim is against that estate. Just because Miss Berry died and now Tiana Wilder is involved doesn't alter the fact of who filed the original complaint against my clients and their right to be reimbursed for expenditures. And we can offset that by what would have been the rent they would have paid after Miss Foxworth died. And that's all in my brief, Your Honor.
Okay. All right. So finish your line of questioning, counsel.
Okay. So, Mr. Eason, and we'll try to make this quick for the court. Did you maintained and you cared for Miss Foxworth and her husband Templeton Foxworth, is that correct?
Yes.
Okay. And you have seen what has been provided to the court with regard to all the expenditures that have been made by you and your family, including your two daughters, for the care and treatment of Miss Foxworth and Templeton Foxworth, is that correct?
Yes.
Okay. And were all the numbers and the dollar amounts and I will go through those with you now very quickly. So there were property taxes that you paid on the property, is that correct?
Yes.
And you paid utilities, the electric, gas, and water bills, is that correct?
Yes.
You also paid for the upkeeping and landscaping of the property?
Yes.
You did repairs to the roof, the siding, the concrete walkway, the main water line, the tree removal, and the normal maintenance of the property during all these years, is that correct?
Yes.
Okay. You also handled the personal upkeep, housekeeping, and the laundry while Miss Foxworth and her husband were alive and you were staying there, is that correct?
Your Honor,
Yes.
objection leading, and also again, this
Well,
is
Your
not
Honor, I'm
before
trying to move this thing along.
Good. Counsel, you made your objection, Mr. Dotto, and that can be a continuous objection. Go
Thank
ahead.
you, Your
And it is true, he is asking leading questions, but just to move this along, go ahead, finish.
Thank you.
Go ahead, counsel.
And you also, as we understand, did you also pay for personal transportation for Miss Foxworth going to various nursing homes, Bryn Mawr Rehabilitation, Kearsley Nursing, Lankenau Hospital, and Devon Nursing Care, is that correct?
Yes.
Okay. And as part of all of that care and treatment, your daughters were also involved, is that correct?
Yes.
Okay, and you did all of that while you and your family were residing with Barbara E. Foxworth while she was alive. Is that correct?
Yes.
Okay, and you continue to live in the property at this time, is that correct?
Yes.
And are you maintaining the property? Have you maintained the property since Miss Foxworth passed away?
Yes.
Okay, and have you paid all the bills and the upkeep of the property as we previously outlined?
Yes.
Okay, and have you made these claims against with regard to this complaint against you to be ejected from the property?
Objection to that question.
Have you made these claims for the expenditures that you made against the plaintiff in this litigation?
Objection, Your Honor.
What's the nature of your objection for the record?
Same objection that I tried earlier where he just filed an answer and he was asking for a legal conclusion. Same thing. There's a legal issue as far as whether or not he has asserted a claim in this case.
No, I'm not asking him for his legal conclusion. I'm asking him if he believes he made a claim for those expenditures.
But I'll allow the question.
Yes.
Yes, thank you. I have no further questions. Your Honor, without going into any detail and going through every number, and I can provide the court with background from all the PICO bills, all the tax bills, the sheriff's sales. We have all those documentations. I did not forward those to the court because it's hundreds and hundreds of pages, but I can provide that.
Sure. All right. All right,
Your Honor,
Go ahead.
Your Honor, we're here today for trial. Your Honor's pretrial order said all exhibits need to be pre-marked and sent into the court prior to trial. It would be highly prejudicial to me at this stage to be able to cross-examine the witness without seeing the documents.
I understand.
So
Okay.
I object on that ground.
All right. Go ahead,
Your Honor,
counsel.
the plaintiff's counsel has all the numbers and all of the
Well,
background.
that has nothing to do with me. I mean, whether he has them, you're supposed to have them before me and we're supposed to be ready for trial. All right. So go ahead, counsel. You may, did you have some questions yourself?
Myself, Your Honor?
Yes.
Mr. Eason, the only question that I have is, you understand that the answer that you filed in this case was only on behalf of yourself, correct?
Well, no, well, I had used the free legal services. prepare the questions for me, but they never told me my whole family had to sign. So I just signed myself. That's the only person I thought that had to sign.
Okay, but you understand, I'll stop sharing. You understand that a default judgment for possession has been entered against the 4 other defendants in this case, correct?
I guess so, yes.
No further questions, Your Honor.
All right, thank you. All
I
right,
would note for the, if Your Honor, please, I would note for the court that Chase Eason is a minor in this, who's one of the defendants who the default judgment was taken against.
okay. Hold on.
I would call the daughter of Mr. Eason. That would be Vivian Eason.
Your Honor, I would ask for an offer of proof, especially since she's been defaulted as a party in this case.
She's a witness to everything that happened, Your Honor.
Yeah. All right, 1 second. How old was Chase Easton? You said he was a minor. How old?
7.
Okay. All right. Counsel, Mr. Dado, you just objected, but I'm going to allow counsel to put her on as a witness. And I take note of what you just said.
Yes,
That
sir.
a default judgment has been entered against her, you said?
Yes, sir.
All right, but that doesn't prevent her from, being a witness. All right. Go ahead.
The only thing that it would not allow for, Your Honor, respectfully, is any testimony on the issue of liability.
Right.
Perhaps maybe damages,
Right.
which I contend is not an issue in this case.
Okay.
But any issues as far as liability have been judicially determined because of the default,
You mean as it relates to her?
as it relates to her, correct?
Yeah, no, I agree. I agree with it. But I
Okay,
don't know
thank
why he wants to present her, and I'm going to give him an opportunity to do that.
Your Honor,
Go ahead,
the
counsel.
offer of proof is simply that, and we can actually, I don't need to present Vivian Eason or Jasmine Eason, the 2 daughters of Mr. Eason. I was only going to present them to confirm everything that Mr. Eason already said. So if Your Honor would accept that they would confirm what he already said with regard to damages, then, and counsel would stipulate that that's what they would confirm, then I really don't need to call them.
Counsel?
No objection, Your Honor.
Okay. All right.
So just so the record's clear.
I'm not calling them to object to the will or the fraud or the deed or any of those issues.
So just so the record is clear, if Vivian, and who was the other one?
Jasmine.
If Jasmine and Vivian were called to testify, they would corroborate Mr. Eason's testimony on damages.
Yes.
Yeah, no objection, Your Honor.
Okay.
Without conceding that damages is an issue in this case. No objection.
Okay.
Thank you, Vivian.
So with that
Thank you,
stipulation in mind, do you have any other evidence or witnesses, counsel?
No, Your Honor.
All right, you rest?
Yes, Your Honor.
All right. All right, so we just need closing arguments then?
Yes, thank you, Your Honor. Again, Your Honor, I think when you take a look at this case and take it under advisement, the legal standard is whether or not Ms. Wilder possesses superior rights, entitlement, and interest in the property. And the record has been clear that she does. And the record's clear because of the following testimony, that Barbara Foxworth had title to the property. Barbara Foxworth had a will. Barbara Foxworth's will nominated Ella Mae Berry as her executrix. That will went through probate. Ultimately, you saw on the probate decree, Ron Donatucci dismissed the caveat filed by Mr. Eason, and the will was duly admitted into probate. Months after that, in April of 2016, as was her legal right as the sole beneficiary of Barbara's estate, Ella Mae Berry takes title to the subject property. Ms. Berry has held title to the subject property since 2016. Mr. Eason has no claim, rights, title, or interest or otherwise in Ms. Berry's estate. He's not related to Ms. Berry. He has no interest in her estate. He has lived there rent-free, and whatever expenses they are going to claim If those were an issue, those should have been raised in the Barbara Foxworth estate. But 6 years later, to come into court after Ella Mae Berry rightfully files a petition for ejectment, and then Tiana unfortunately passes away, and Tiana is substituted as the representative party, the claims are whether ejectment is proper, and ejectment is proper. Any claims as to A, the expenses should have been brought in Barbara's Foxworth's estate, and B, should have been brought as a counterclaim for unjust enrichment or otherwise in this particular case, and they didn't. Now, Mr. Fichera on his opening, on his closing, will likely say, well, they were acting pro se. Well, the fact of the matter remains that Mr. Fichera became counsel of record for Mr. Eason, the only one who has filed an answer in this case, never moved to amend the answer to raise any type of affirmative defenses. So all affirmative defenses, Your Honor, are waived, or any counterclaim is waived because it's not been properly brought before the court. So for those reasons, Your Honor, we would ask for a judgment and ejectment, and we appreciate the court's time and attention to this today.
All right, thank you. So just two quick questions, and then defense counsel can give his closing. And like you said already, the main premise of your complaint is ejectment. It's an ejectment action.
That's right.
All right. And you said something, I think, in your closing, and maybe you did bring it out during the evidence as well. But I just want to be clear. You said that Mr. Eason lived in the property rent-free.
Well, the reason that I say that is, Your Honor, because he claims in this memo that was submitted by his counsel that he's paid all the expenses. I've never seen any proof of that, never seen any canceled checks. I already had him admit, for purposes of the record, that there wasn't any written lease. So it's just self-serving testimony that he's paid these expenses. So that's
you
why
believe, based on your argument, that he lived there rent-free.
Respectfully, I submit that, Your Honor.
For the whole time, pretty much.
Your Honor, I don't know what existed before 2016, but certainly since 2016, I've not seen any evidence of any type of expenditures for rents or otherwise.
All right, thank you. All right, defense counsel, closing.
Yes, number one, Your Honor, Mr. Eason is related to Miss Berry. Miss Berry and Miss Foxworth were sisters. Mr. Eason's mother was their sister. So
keep your voice up, counsel, if you don't mind.
They
are related. They are related. Go ahead.
Yeah. Okay. He's her nephew as well.
Okay.
With regard to closing argument, Your Honor, we get back to the issue of when you asked about being rent free. The defendants have been lived at the property with Miss Foxworth and her husband until her husband passed away and Miss Foxworth passed away. They were living there and they were taking care of Mr. and Mrs. Foxworth.
Were they paying rent?
Excuse me?
Were they paying rent?
No, they were not paying rent because the agreement was that they would take care of them and they would live there. And the reason they were allowed to live there rent free was to take care of them. At the time that they were living there, they were providing all the personal services, nursing care, home care, transportation, doctor care to Mr. and Mrs. Foxworth at the time that they were there. That's why they were living there. And you've heard this from other cases that I heard today that came before Your Honor, that they were there for that reason. After Miss Foxworth told them they could stay there because they were taking care of them. Now, after Miss Foxworth died, they continued to stay in the property under that proposed agreement, which was a contract between them and Miss Foxworth. And they continued to maintain the property. There was a sheriff's sale put up for lack of taxes. They worked that out. They paid the sheriff's sales taxes. They paid all the bills. They've paid all the upkeep of the property. They paid landscaping. They paid for everything that has to do with the property. Now, for counsel to say he has no idea what's going on at the property and whether or not they're paying the bills. If PICO wasn't being paid, the water bill wasn't being paid, the tax bill wasn't being paid, and none of the bills were being paid, there would be judgments against the property that would go against Tiana Wilder because she now owns the property. There would have been a sheriff's sale, which actually did take place for lack of payment of the taxes, which my clients then paid and had the sheriff's sale removed. And so all of these payments have been made by my clients, and this court can certainly take, and counsel cannot argue that didn't happen because he hasn't seen any canceled checks. They have paid all the bills, and counsel clearly should concede that they've been paying all the bills. I have provided him with everything he needs to know about this. So all we are claiming at this point, Your Honor, is that if these people are ejected from this home because Tiana Wilder is now the owner of the property and she wants them out, they should be reimbursed for all the expenditures they have made with regard to the maintenance and upkeep of this property.
But sir, what evidence have you presented during the trial in terms of those expenses?
Your Honor, I provided you with a breakdown of all the expenses.
I mean, how much are you talking about though? And maybe, just so we're clear, because doing this by Zoom is not always the cleanest.
$439,000.
439,000.
That's over 12 years.
All right, and correct me if I'm wrong, but that's taken into consideration some of the time period when the deceased was living as well, and they were caring for her,
Yes,
right?
that includes the care and treatment of her, and that's all broken out in my brief to you, Your Honor.
Okay. All right. Anything else, sir?
Not at this time, Your Honor.
All right. Thank you. I appreciate the two of you, the professionalism that the two of you exhibited during the trial. And I have listened to your arguments. I'm going to look at the evidence that was presented to me very carefully, and you'll have my decision in the very near future. Okay?
Thank you, Your Honor.
All right. Have a good day.
Thank you.
All right, questions? Nope.
Thank you. So that ends this particular proceeding.
That's all of it.
All right, thank
Right.
you.
Thank you.
Have a great day. Thank you.
Time's down, 12:06, court is adjourned. Wait for them to, if you want to end the meeting, I don't know if you want to talk to Janice.
Yeah, just for a second.
I just want to wait for them to
Yeah.
get off the.
Janice just had a quick question.
I got a CLE. I'm about 5 minutes late, but that's fine. I'm just gonna jump on that real quick
Okay.
for the next hour.
All
I was just gonna say it doesn't.
Wait, make sure.
No, they're gone. It
Give me
doesn't-
1 second.
It doesn't matter. They may have a claim for unjust enrichment, but they didn't make a counterclaim. They can't just bring it up at the time of trial,
Yeah.
so we're gonna eject them.
Yeah.
Um,
And that's all his claim is looking for anyhow.
Yeah, I mean, if they want to file an unjust enrichment, because we're not a court of equity.
Yeah.
This is sitting in ejectment.
Exactly.
This is
And
like.
that's what I was thinking.
Yeah, like
Yeah.
he's saying like, oh, this is a court of equity.
Yeah.
No, it's not right
Yeah.
now.
Yeah.
So
Yeah,
I
exactly.
don't know what the hell he was talking about, but
Yeah.
yeah,
Well,
they wanna-
I'll check with my, the law on ejectment. I don't know if I can automatically do that in my own capacity. I don't
Well,
think
first
so.
of all,
though.
like
Yeah.
you couldn't entertain a counterclaim for unjust enrichment
When
because
there's
they
no
never
claim,
raised it.
yeah.
Like you can't just raise the day at trial. That's prejudicial.
Right, I got
So,
you.
I
Yeah.
mean, they can feel free to file a complaint later, but-
Gotcha. And I don't disagree with you. All right, can you hear me?
Yeah, I can, Your Honor, but can Brian take off the YouTube?
Oh, yeah. Hey, Brian. Brian. Brian.
Yes, coming, sir.
Yeah, we're still on YouTube. You have to.
Huh?
Are we still on YouTube?
We are.